Thank you. We now move to the next section of business, which is a debate on motion number 4234 in the name of Kenny McCaskill on public consultation on the Carloway-Report reforming Scots criminal law and practice. Members who wish to take part in the debate should press the request to speak buttons now. Can I say to all members that we can be generous if members take interventions, and I call on Ken McCaskill to speak to and move motion. Cabinet Secretary.
Thank you, Presiding Officer. Today's debate is a timely opportunity to engage members in the further development of the historic reforms proposed by Lord Carloway in his report on criminal law and practice. And let me once again thank Lord Carloway for his report and the huge amount of work that lies behind it, and indeed congratulate him on his recent appointment as Lord Justice Clerk, which I'm sure will be shared by all the Chamber. The debate is also timely because the First Minister announced in the programme for government a criminal justice bill that will enact Lord Carloway's proposals. It is also timely because the Scottish Government is currently running a consultation on how to implement those proposals, and this is an opportunity for members in this chamber to contribute to that process. Members will recall the decision of the UK Supreme Court in HMA v Cadder and the emergency legislation which had to follow upon it, and I'm grateful for the forbearance of all those who participated in that. And while the emergency legislation has proven effective as an immediate response, there was, and is, a clear need to reappraise our justice system for the future. I believe that Lord Carloway has provided us with a clear and coherent package of reform, from first arrest and detention through to the ultimate final appeal. His recommendations are clearly reasoned, carefully constructed and closely interconnected. They provide us with a landmark opportunity to redesign our system around modern, fundamental concepts of human rights, as well as preserving the integrity of a system that we are rightly proud of. The Scottish Government consultation paper on the Carloway Report reflects on comments and developments since the Carloway recommendations were published last year. It covers debate in this chamber, before the Justice Committee, and indeed beyond. And I'd like to express my appreciation of the committee's work and my thanks to all those who gave evidence. And although I've made clear my view that Lord Carloway's recommendations, as I've alluded to, are a comprehensive package from first arrest to final appeal, there do remain many issues to discuss on how they can be made a reality. As always with legislative matters, the devil is in the detail. By all means.
Lewis MacDonald.
I'm very grateful and I welcome today's debate. Can he assure us that his comments about the process so far do not imply that this is the last we will hear of these matters before a bill is produced? In other words, once the consultation is complete and we know the views of all parties, will Parliament have a further opportunity to consider those responses?
Cabinet Secretary.
No, I think that's a fair point that Lewis MacDonald makes. Obviously, the consultation is not yet concluded, although we've got a clear steer and a direction. Obviously, there will have to be discussions before an appearance, no doubt, before the committee, but I can give an assurance that we're going to take time to reflect. I'll be more than happy to engage with him and with other Justice spokesmen, indeed anybody else, about our direction of travel. But I think I can give him a clear assurance that what we intend to do is to provide as much opportunity to see if we can reach as much consensus as is possible. That might not be entirely possible because there are strong views held on some aspects, as I'll come on to, in corroboration on either side, and ultimately you might have to come down on one side or other, as I'll mention. Equally, as I say, I think we should take the opportunity to debate and engage and indeed to try and focus, so that ultimately when we do proceed, we have brought as many people on board and we do have as good a majority as is possible. But it is clear from the debate in the committee sessions that many of Lord Carloway's recommendations have been widely welcomed and accepted. There has, of course, been debate and challenge to some of the recommendations, for example, on the role of the Scottish Criminal Cases Review Commission. But most of the focus has centred squarely on corroboration, and I shall return to that issue shortly. It's not my intention to revisit here the debate on CADR or even the general findings of Lord Carloway-Report's report. Instead, I would like today to focus on how Lord Carloway's recommendations are taken forward. This is the approach of the Government's consultation, and I would now like to focus on some of the key questions posed in the consultation paper. The consultation paper accepts the recommendations for sweeping change to the system for arrest and detention of suspects. Allowing the police to arrest suspects on reasonable suspicion should provide a transparent and easily understood process. These changes balance the needs of the police and their duty to investigate crime with recognising the rights of individuals. The consultation seeks views on whether Lord Carloway's proposed maximum periods of 12 hours for detention and 28 days for investigative liberation are sufficient, whether there should be extensions in certain exceptional circumstances. The consultation also asks for views as to the practicalities of investigative liberation and what challenges this presents operationally, and I look forward to debate on these issues. On the length of time suspects spend in police custody, Lord Carloway observes that if suspects are held for longer than 36 hours under the new regime, then weekend courts should be considered. The Government fully accepts that suspects should not be held unnecessarily or disproportionately in police custody pending appearance at court, and the consultation seeks views on the best way to bring suspects before a court as quickly as possible. Advances in video link technology may be part of the solution, helping to offset some of the operational and financial challenges involved, because we all know that technology does make some savings, but equally it comes at a cost. But it would also be fair to say that Lord Carloway and our consultation on these aspects is not going forward in isolation. The Government's Making Justice Work programme is seeing matters coordinated and work ongoing between police, legal aid board, prisons and courts to make sure that aspects can be dealt with. Some matters, some members may already have had the opportunity to see prisoners in Barlinnie at full committal or elsewhere being able to be dealt with by a sheriff sitting in Glasgow Sheriff Court. Some of these aspects will be capable of being replicated and used across, and certainly with regard to the aspects and reference made by Lord Carloway. On suspects accessing legal advice, the Government agrees in principle with the recommendation that legal advice for suspects is provided at the point of detention. There are legal aid implications to this, and the consultation seeks views on how to deliver the recommendation in a way that is both effective and affordable, because as with technology, legal advice comes at a cost. But work is underway, and the Scottish Legal Aid Board are engaging with the Law Society and other representatives. In relation to child suspects, Lord Carloway restates the requirement for suspects to obtain legal advice from a solicitor before and during questioning. He accepts that suspects may decline the right to a lawyer, but recommends special protections for child and vulnerable adult suspects. The consultation places this within the general context of trying to avoid children accused of minor offences being unnecessarily drawn into formal criminal justice processes, while at the same time ensuring that there is a strong system of protection for those suspected of serious offences. and I would urge members who I know have a particular interest in this to participate in the consultation. These matters are, as I say, subject to engagement, and agencies, whether families outside or other organisations, are seeking to make sure that we get the balance right. On legal aid, the consultation paper highlights where some of the changes to criminal investigations and prosecutions will have a substantial effect on the legal aid budget. Clearly, we must continue to ensure that people have access to legal representation when they need it, and that solicitors are fairly remunerated. At the same time, we must consider the potential implications for legal aid expenditure in Scotland in a time of reduced budgets. But as I mentioned earlier, this is a matter in which the Scottish Legal Aid Board are seeking to engage constructively with the Law Society, and I would put on the record my thanks to the Law Society for the tolling, if I can put it that way, and the constructive discussions that we've had with them over recent periods on matters that predated and indeed postdated the Cadder decision. We cherish, as a government, the independent role of the Scottish Criminal Cases Review Commission. They are a critical part of the checks and balances in justice. There was some considerable Justice Committee debate as to the merits of the appropriate level of powers of the High Court when considering cases referred by the Commission. We will listen closely to the views offered in the consultation as regards the finality and certainty recommendations. That then leads us, and I should now turn to corroboration. This, after all, is the matter that has perhaps, understandably, had the most interest and sparked the most comment, although I do believe that Lord Carloway's matter is a package dealing with matters, as I mentioned, from the very first point of arrest, due to the very final outcome of the ultimate appeal. But Lord Carloway explains that the rationale for the rule stems from another age, that its usage has become subject to overly complex rules, and that it can bar prosecutions that would in any other legal system seem entirely appropriate. I do think it is a matter that we should give some consideration as to why, in his research and endeavours, no other country in the Western democracies appear to have such a rule. And as I say, that's a matter that we should reflect upon. I do think that Lord Carloway has made a compelling case. As a Scots lawyer, once, no longer, I share the historic pride in our system that inspires many to argue for the requirement to remain. But I can also see that there are times when the tide of history becomes too strong to resist. As I said, Lord Carloway could find no other Western criminal justice system with a general requirement for corroboration. And while I have a good conceit of the justice system in Scotland, I equally am also an admirer of many other Western democracies who I think managed to get the balance correct, by all means.
Christine Graham.
Comparing systems, would the Cabinet Secretary concede that we're not always comparing like with like, that other systems will not have majority verdicts or not proven verdicts?
Cabinet Secretary.
Well, I think, Christine Graham, it's a fair point. We do have within the Western criminal justice system some systems that are adversarial, some that are inquisitorial, some that tend to be a hybrid in between. The points that she also makes are equally valid, and I'll be coming on to them because certainly there are requirements, I think, that many people are mentioning that they feel will be necessary if corroboration is to be dispensed with, as Lord Carloway alludes to. He did find that the rule focuses artificially on quantity rather than quality of evidence. He did find that the law had developed into a tangle of complicated rules applied differently from court to court. And he did find an alarming number of cases that might have reasonably gone to trial with a different test for sufficiency of evidence. I appreciate that abolition causes concern to many. Indeed, it would be worrying for there not to be a debate around changing something that is so synonymous with Scots law. However, I note that much of the concern has rightly focused upon whether abolition should proceed without any other changes being made, which is the point understandably and correctly being made by Christine Graham. First and foremost among the views expressed has been that it would be unfair to remain at a simple majority for jury decisions. There are also wider points about how judges direct juries and how they decide that a case is not strong enough to go before a jury in a specific case. And I've also noted with interest Michael McMahon's Members' Bill seeking to reform our three-verdict system. These are all issues where I welcome debate and responses to the consultation. I'm not minded to revisit Lord Carloway's recommendation on corroboration. I'm not minded to refer this issue to a Royal Commission for further study. The requirement has been appraised and found wanting by the second most senior judge in our country. To conduct a further review strikes me as simply extending the current uncertainty over our system for years to come, an uncertainty that we've had to address in some aspects by emergency legislation. But I am fully committed to listening and reflecting upon all consultation responses that look at how reform can best be achieved, and if necessary to bring forward proposals for additional protections that may be needed to create a fair and balanced system. I therefore call on all interested parties, whether those speaking today or those responding to the consultation, to tell me about what, if any, additional safeguards they think need to be put in place. I am aware of recent criticisms of this Parliament's legislative record, even going so far as to draw unfavourable comparisons to Westminster's reforms of Scots law. As you would expect, I repudiate those claims utterly, but they lead me to stress the importance of engagement. If stakeholders want a different course of action, they should make that case and show us the evidence that supports it. This consultation is the time for engagement, as I said earlier to Mr MacDonald. The Carloway-Report is but one part of a coherent modernisation package underway. This will bring together under Carloway, with Lord Gill's recommendations for reform of the civil courts, Sheriff Principal Bowen's proposals for sheriff and jury reform, and ongoing work to improve the efficiency and effectiveness of the summary courts. Taken together, this will give us the right legal framework, court structures and procedures for many years to come. We do need to re-evaluate our criminal justice system following Cadder. We do need, as I say, to show the deference and respect to Lord Carloway for this. I do believe that there will have to be further consideration of the aspects that are brought forward regarding corroboration, but I do believe that we should not hesitate and lose this historic opportunity to review and reshape our justice system for the 21st century. I move the motion in my name.
I now call on Lewis MacDonald to speak to move amendment number 4234.1. Mr MacDonald, you've got around 10 minutes.
Thank you very much, Presiding Officer. The Government's motion today highlights the importance of delivering these measures in a coherent way alongside wider reform to courts and tribunals. And we agree with the principle underlying that phrase that law reform cannot be considered in isolation from the practical context in which the legal system operates. That is why we have brought forward an amendment which makes even more explicit the link between the consultation on Lord Carloway's proposals and the consultation on the future of the court service, already flagged up by Ian Gray's topical question earlier this afternoon. We could hardly be in more topical territory. The consultation on Carloway is due to close in 10 days' time on the 5th of October. The Government's announcement of plans for a criminal justice bill was made to Parliament, at least in the legislative programme, on the 5th of September. Only last Wednesday, the Government's budget confirmed that funding for the court service is to be cut by 10% in cash terms, 14% in real terms, over the next 2 years. And the consultation on court closures began only last Friday. So there's a lot happening, but the question is whether the Government's enthusiasm for changes to the prosecution of crime, its cuts to the court budget and the proposals for court closures add up to a coherent approach, as is called for in its own motion today. The answer appears to be that they do not. Lord Carloway's review did indeed make a compelling case for change, not least on the central issue of the need for corroboration. By any measure, however, the implementation of such recommendations is bound to increase rather than reduce the burden of work on Scotland's courts, not to mention the implications of the parallel reviews by Bowen on sheriff and jury trials and by Lord Gill on civil justice.
John Finney.
Thank you, President Officer. I'm grateful for the member taking intervention. I wonder in relation to the requirement for corroboration, surely if one officer rather than two police officers is turning up at court, there's a saving.
Lewis MacDonald.
I absolutely accept John Finney's point. There are clear benefits in these proposals. My point, though, is what is the consequence of removal of the need for corroboration on the sheer volume of cases likely to be considered by our courts and placed before our courts. And on the impact of removing the need for corroboration, as John Finney raises, the evidence is there in Annex A to the Carloway report. The Crown Office examined the records of 600 serious criminal cases and sexual offences in 2010, which were dropped either after an initial court appearance or before coming to court at all, and they found that nearly 60% in one category and two-thirds in the other would have had a reasonable prospect of conviction if the requirement for corroboration was not there. Had those been taken forward, 350, 400 additional cases been taken forward, they would clearly have represented a significant extra caseload for Scotland's Procurators Fiscal to take to Scotland's courts. And bearing in mind, of course, that we're talking here of serious and sexual offences. The proposal to remove the need for corroboration would, of course, apply to all crimes, not just to those. So the number of extra cases would have been even greater than the numbers identified in the Carloway report and in the government's own consultation paper. And, of course,
Cabinet Secretary.
The matters referred to by Lord Carloway that he also commented on are cases where there are real doubts about whether justice has been done. Whether there would ultimately be a conviction is a matter ultimately for the court, but we should do everything that we can to strive and do that. Equally, Lord Carloway is suggesting that in the main matters should proceed by way of seeking corroboration for a conviction. But the matter correctly referred to by John Finney is that considerable savings will be freed up instead of two officers routinely going to London, going to Edinburgh, going wherever to uplift a label and then requiring to speak to it in court. That what we will see is justice dealt with at higher levels and savings made where they should be in matters that, frankly, you have to question why two officers are required to speak to a label.
Lewis MacDonald.
I think I accept every point that the Cabinet Secretary made in that intervention, and my purpose is not to say that there is no case for removing the need for corroboration or that we shouldn't do so. I completely agree with the Cabinet Secretary that justice should be done and done in as many cases as is possible. My argument is not that therefore we should have no change in the law of corroboration. My argument is that if that is the case and it produces more work for the courts and for the fiscal services, then that should be reflected in the support they receive from the government instead of the trend going in the opposite direction. Since the piece of research was done on those serious cases of 2010, the Procurator Fiscal Service has seen a 4% increase in the number of crimes reported for action in a single year, an 8% rise in the serious crimes reported on petition in the same period, and according to the Procurators Fiscal Society of the First Division Association, an 8% reduction in the total number of in-house legal staff over 2 years. The Lord Advocate has also suggested, in addition to the points made by Mr McCaskill and Mr Finney, that removal of the need for corroboration could have retrospective effect, not in cases which failed, but where no proceedings were previously taken because there appeared to be insufficient evidence to proceed. Again, if that's the case, clearly it would be welcome if the outcome was that justice was done. But if there are many such cases, then there will be a particularly heavy demand on the time of fiscals and of courts over the next couple of years, precisely the time when government budget cuts are likely to have the greatest effect. The Law Society and others have argued that changes of the scale proposed by Carloway should only proceed in the context of a full-scale review of Scottish criminal procedure. We do not favour endless delay, but it would be helpful if the government's budget decisions supported the law reform approach they want to endorse, instead of undermining it by taking resources away from the front line of service delivery at the very time they're needed most. And of course, the Law Society is not alone in raising concerns about what they see as undue haste and urging caution in how we proceed. Scottish Women's Aid, for example, supports the proposal to remove the requirement for corroboration, but has raised real concerns about the proposals for police bail. They worry that liberation from custody could allow an accused person to tamper with evidence or intimidate witnesses. In domestic violence cases, the victim may be directly under threat as a result. They are concerned, from their experience, about how a victim would be advised of a suspect's liberation, how a suspect's compliance with conditions would be monitored, and how breaches would be dealt with by the courts. Those are not trivial matters. They're not arguments against proceeding either, but they do suggest that there are questions that still have not been answered by those who need those answers the most. And in that sense, perhaps today's debate is a little premature. Members can raise issues, ministers can respond, but as we are not yet at the end of the consultation period, this is bound to be an incomplete process. A debate following the government's response to the consultation process would clearly be helpful, and I'm glad that Mr McCaskill has agreed that that should happen today. But of course there are policy issues as well as resource issues on the key question of corroboration. The Scottish Law Commission, for instance, has argued that corroboration and majority verdicts are two sides of the same coin, and that there should not be change to one without change to the other. If the requirement for corroboration is removed without reforming majority verdicts, so the argument goes, then an accused person could be convicted on the evidence of a single witness and by a prosecution case which convinces only 8 jurors out of 15. Of course.
Margaret MacDonald.
It's a question I have which may be completely ridiculous, but I want the answer to it. Since there are different standards of proof required in different sorts of cases in Scots law, is there any reason why the crime of rape or the accusation of rape should not be in a category by itself, should not need corroborative evidence, while everything else remains?
Mr MacDonald.
It's an interesting proposition on which no doubt members and indeed ministers will want to reflect, but I think the principle of corroboration, the need for it or the lack of need for it, is something that as a matter of principle would apply to every law, to every offence or to none. And that would be my, as a non-lawyer, that would be my response to Mrs MacDonald's question. But I'm sure it's something on which others will reflect in the course of this afternoon's debate. But in relation to the majority verdict, there is also the issue of the not proven verdict. And again, the Law Commission has raised concerns about that if there is no longer a need for corroboration. Their argument again is that if the only reason a jury does not convict is the absence of corroboration, then if that is no longer required, they will presumably straightforwardly find the accused person guilty. If the evidence is still not convincing, even in the absence of a need for corroboration, they should equally straightforwardly find the accused not guilty. Whether agreeing with the Law Commission or not, many people clearly take the view that removing the need for corroboration must be followed by an indication of what safeguards will take its place. So far, ministers have chosen not to go down that route, although I listened carefully to the Cabinet Secretary's comments on the matter, and I was pleased that he sounded as if he had at least not closed the door on action in those areas. Their own consultation paper described the not proven verdict as one that offers the jury a verdict which accepts there is evidence against the accused, but not enough to convict. But surely, in every case that is brought, there is evidence against the accused, and the argument for having a third verdict is surely that much the weaker in the light of the changes that are proposed. In the debate in the legislative programme earlier this month, I called on ministers to engage with Parliament in the evidence to be taken on Michael McMahon's Members' Bill on these issues, and I repeat that call this afternoon. It is important to get the balance right and to pay heed to all of the evidence. It is important to recognise that this proposed bill is not just about the issue of corroboration or indeed issues such as police bill. There are changes proposed, as the Cabinet Secretary has said, across a wide range of issues of procedure and practice. There are important proposals, for example, on the legal rights of vulnerable adults and of children, the knock-on effects of extending the protection of children to those aged 16 or 17. As ministers themselves have admitted, they worry about the cost of extending the right to legal advice to persons who are not being questioned in a time of reduced budgets and in the context of their already controversial proposals to cut criminal legal aid, even for people on relatively modest incomes. I hope ministers will accept the link between Carloway and court restructuring, agree that a fully informed debate must continue and come back to Parliament after the closing of this consultation, and be prepared to consider carefully their stance on majority verdicts and not proven in light of evidence taken in the parliamentary process on Michael McMahon's bill as well as their own. and I move the amendment in my name. Thank you.
Thank you. I now call on Margaret Mitchell to speak to and move amendment number 4234.2. Ms Mitchell, you have around 7 minutes.
Thank you very much, Presiding Officer. I welcome the review carried out by Lord Carloway into criminal law and practice and the subsequent consultation by the Scottish Government. With hindsight, it's perhaps surprising that pre-2010, before the Supreme Court's decision in the Cadder case and the emergency legislation which followed, no one questioned the practice of police interrogation of suspects without the presence of a solicitor. So today's debate provides the opportunity to look at past shortcomings in the justice system in this respect. The Carloway Review contains a number of useful and well thought out proposals which are widely supported and include the streamlining of the concepts of arrest and detention, the proposals on timescales restricting detention without charge, and a new statutory definition of vulnerable suspects. But there have been mixed comments about the proposal for police investigative bail. Whilst the Law Society has welcomed the proposal, Women's Aid have raised concerns about the effect on victims of domestic abuse, highlighting the difficulties in ensuring victims are notified of the suspect's temporary release prior to charge or report to the PF and pending further investigation. However, as the Cabinet Secretary confirmed, it is the proposal to abolish corroboration which has attracted major and widespread criticism. Given this, I call on the Cabinet Secretary to implement the other less controversial proposals of the Carloway Review, but to defer the abolition of corroboration for further consideration. This makes sense for a number of compelling reasons. Firstly, we can't predict how many cases would actually result in conviction if the requirement was abolished. We do know the Carloway Review research concluded that out of 458 cases, where the case had been marked no further proceedings due to insufficient evidence, 81% of these cases would have been likely to be prosecuted further, with nearly 60% having a reasonable prospect of conviction. Furthermore, about 5,000 serious cases are prosecuted under solemn procedure before a judge and jury each year. Removing corroboration is estimated to affect less than 10% of cases and leads to conviction in barely 5%. And as the standard of proof in criminal cases is beyond reasonable doubt, in practice, corroborated evidence is likely to continue to be the norm. Some people support abolition of corroboration as a means of addressing the poor conviction rates for rape cases. Whilst it is worrying that only 5% of reported rapes lead to prosecutions, in England and Wales, where there is of course no requirement for corroboration, the conviction rates for rape cases are no better. This suggests there are many other factors at play, and this is confirmed by the views which I sought from some members of the cross-party group on adult survivors of childhood sexual abuse. Importantly, it was emphasised by these members that the justice system must protect the right of the accused against false accusations. Some members had witnessed situations where there would have been a serious miscarriage of justice had the rules on corroboration not existed. Whilst acknowledging that corroboration can make it even more difficult to secure convictions, it was pointed out that complete abolition could lead to yet more plea bargaining, drastically reducing sentences which are already viewed as paltry for rape, sexual assault, child sexual abuse and domestic violence. Instead of abolishing the law on corroboration for these interpersonal cases of violence, where the execution of the offence has relied on secrecy and concealment, a much wider definition of corroboration could be permitted, which would still maintain the principle of fairness to the accused. It was therefore strongly advocated that the current law on corroboration application and definition be revised rather than abolished. The following measures, rather than legislation, would encourage a more proportionate and considered approach and increase the chances of victims and survivors accessing justice in criminal proceedings. Yes, certainly.
Cabinet Secretary.
What is meant by further revisal of the law of corroboration, given that it has been revised so that we have evidence by corroboration by admission, corroboration by special knowledge, over many centuries we have revised and indeed ameliorated and watered down corroboration, so it's not, as many members of the public think, two particular police officers or two individuals. What further suggestions are you making?
Margaret Mitchell.
I think some of the suggestions which I'm just about to give you from some of the adult survivors make it clear that rather than abolishing this without looking at within the full context of a full and comprehensive review of the law of criminal procedure would be worthy of looking at. So perhaps the Cabinet Secretary will be convinced when he listens to these. And they include enabling more cases to be taken to court with a more robust use of the Murov doctrine. Just now there's a very definite time-limited element to that which dilutes this an important piece of evidence which could help with convictions. Training of PFs and court officials on sexual abuse and the impact on victims, changing the ways that victims of sexual crime are cross-examined, more use being made and weight being given to the testimony of expert witnesses and more realistic sentencing. It was also emphasised that it was not tenable to rush unnecessarily to abolish corroboration for all crimes because it was thought to impede convictions in some instances. In conclusion, Presiding Officer, corroboration was introduced to protect against miscarriages of justice, reducing the prospect of a judge or jury convicting the accused on the basis of a single piece of testimony. By removing corroboration, to quote one leading QC, the evidence of a single duplicitous and lying skillful witness would be sufficient to put a person in prison for the rest of his life. Quite simply, corroboration cannot be considered in isolation of the wider law of criminal procedure. The government must take time to get this right, and for this reason, I move the amendment in my name.
Many thanks. We now turn to the open debate, and it will be speeches of 6 minutes with some time at this stage of the debate for interventions. I call Christine Graham to be followed by Graham Pearson.
Deputy Friday Officer, can I have a little moan first and ask the Business Bureau reflect on the fact that this is essentially a justice debate when the committee has been sitting until 12:45 today with a substantial agenda, and indeed I had to guillotine business to allow members a breathing space and a little ham roll before they came here. Isn't it possible to ensure that for the Bureau, when we've got virtually subject debates in the afternoon, it doesn't take place in the day that a committee has been sitting in the morning? I feel better for that. Can I also say the consultation is still ongoing, so the timing of this debate is a bit of a mystery to me. However, you can all take this as my contribution to the consultation. Now, I notice the government motion where to highlight the phrase to deliver these reforms in a coherent way. And I think that's the issue for me about coherence. Because if you look at the remit for the terms of reference for Lord Carloway, it was not asked to consider not proven or majority verdicts. It was put within a very specific context. Paragraph 2, haven't got time to read it out to you, but you'll see what the terms of reference were. Now, this takes you to which I've aired before here, my concerns about proposed abolition of necessity for corroboration in criminal cases. It's not new, and it's not just mine, and I refer the Cabinet Secretary to the letter from the Justice Committee sent the 26th of January this year, and a couple of sentences I think I'll quote fairly. The committee noted an underlying consensus that the corroboration rule should not be seen as sacrosanct, and that it was legitimate to reinvestigate from first principles whether it continues to serve a useful purpose in 21st century Scots criminal law. Fair enough. We then went on to say, it was important to ensure that any future work on corroboration should avoid considering that single issue in isolation. Instead, it should also take into account the complex web of factors that, taken together, set the current balance between the state's ability to secure conviction and the individual's right to a fair trial and to be acquitted where there is a reasonable doubt. Now, I think that's terribly important. And I'll take the oft-quoted example of how this would lead to an increase in successful, this is to no longer have necessity for corroboration, it would lead to an increase in successful prosecutions in cases of alleged rape. And first of all, I say to Margaret MacDonald, you can't take one particular crime and say we don't need corroboration in this, we'll park the others. Let's take serious sexual assault. It would be far, far worse in some respects for the victim than rape. But you would be saying you would need corroboration in this and not in something else. No, I'll debate that afterwards. Don't think so. Now, Sandy Brindley from Rape Crisis Scotland thinks that it would be a great idea to abolish corroboration in cases of rape, but I have a much more cautious view. If it simply comes down to credibility of the accused and the credibility of the witness, the alleged victim, it's perfectly open to the defence advocate to conduct a rather brutal cross-examination of the alleged victim on behalf of his client, addressing previous sexual behaviour and so on, the behaviour that evening. Why not? And some people will look like victims, behave like victims. Some will not. Some people will look like rapists. Some will not. And in addition, as I've already said, we retain majority verdicts. Remember, the Crown must prove its case beyond reasonable doubt. The accused is innocent until proven guilty beyond reasonable doubt. If a member of the jury says rightly, this is about credibility, I have a wee bit of a doubt. There may be many more acquittals, not guilty, not proven, appeals, referrals to the SCCRC, perhaps even increased use of double jeopardy, bringing in evidence that allegedly wasn't available at the first instance. Add to that, as far as I can see, there is no evidence, say in England and Wales, that removal of the necessity for corroboration has led to an increased successful prosecution in rape. Now, given the pressures in time, I've not been able to ascertain the number of hung juries, retrials south of the border, where there has to be a unanimous verdict, but that would be good evidence to have. So I've dealt with that. So I'm sympathetic to the thrust of the amendments on the other side. I don't agree with everything in them, but I'm sympathetic to the thrust. The second issue is the removal of the gatekeeping role of the High Court when a referral is made from the SCCRC, which was introduced in the 2010 emergency cadre legislation. In other words, the High Court should not be allowed to reject a referral from the SCCRC in the interests of finality and certainty. They're judge and jury in their own case. That's fine for me, but not far enough. Even if the High Court has an appeal referred, and then hears the appeal and agrees there's been a miscarriage of justice, it still is allowed to consider whether it's in the interests of justice to allow that appeal. Now, I'm a simple soul, and I thought if there had been a miscarriage, and it's been proven there's been a miscarriage of justice, then it's miscarriage of justice full stop, and that appeal should be allowed.
Thank you very much. Graham Pearson, to be followed by John Finney.
Thank you, Presiding Officer. The Carloway-Report marks an important milestone for the administration of Scottish justice, containing, as it does, many and complex recommendations, and the opportunity to redesign, refresh and update Scottish criminal procedures and provide the citizen with an appropriate protection in the face of state intervention. I welcome the report. Such opportunities come barely once in a lifetime and must not be squandered. There are those who would resist change, insisting that our system for the administration of justice is amongst the best in the world. The reality, I feel sure, is somewhat different. A reality that demands we learn lessons from experience and improve where we can. Others have already commented on many aspects of Carloway. I intend to focus on one element of the report. The element of Carloway attracting much attention attaches to the question of corroboration and its value in terms of a required standard of proof in criminal cases. For hundreds of years, the principle of corroboration has stood the test of time, a necessary check for the courts in weighing the level of evidential material necessary to prove guilt, not solely in terms of avoiding miscarriages of justice, but also as a means of protecting an accused from a callous or criminal attempt on the part of prosecutors to use a single witness or piece of evidence to convict a citizen. Corroboration was, and by many is still seen as an essential safeguard. I have to say, initially I shared that view. My experience in previous working life indicated that though operationally inconvenient, the need for corroborative evidence ensured prosecutors pursued an investigation with a view to providing not only a sufficiency of evidence, but a level of confidence in the integrity of that evidence provided. However, Lord Carloway provided evidence to Justice Committee explaining his thinking in detail, and I was impressed with his explanation of the nature of evidence in terms of its quality rather than the quantity provided, and I have to say I was persuaded by his arguments in principle. I would nevertheless want to hear in detail what this government proposes. How does this government wish any new approach to be implemented? Is it a blanket abandonment of the need for corroboration on an agreed date? Or will the changes be retrospective in their application? Will the government expect a series of cold case reviews by Crown Office? Or is it the intention to set a date and a calendar from when corroboration will no longer be an essential part of the process? There is no doubt Scotland is out of step with much of the rest of the civilised world in this regard. Nevertheless, the government should not carelessly cast aside a much valued safeguard without properly setting out precisely what it intends to replace it with for the future. Particularly in a Scotland where the SNP government seek to cut a legal aid budget over the next 3 years by up to £20 million in real terms, cut court administration costs by £3 million, have an expectation that solicitors will gather from clients an element of fees not currently covered by legal aid provision, or, novelly enough, accept that lawyers will take the loss of a fee as a good decision in the light of possible business opportunities in the future. The prospect of closures of many of our local courts hearing evidence in criminal cases, and the possible abolition of independent prison visiting committees, not to mention my own very particular concern about any meaningful democratic oversight of a new national police force. Taken together, these steps do not enhance the rights of suspects, nor provide a balanced approach to criminal justice. They do provide real reasons why we must have clarity in respect of the government's intentions. Many of Carloway's recommendations make sense in a system properly maintained and properly administered. When added together, these cuts and changes create a real test for justice seen and justice delivered. I hope to be assured that government ministers understand these challenges and will deliver a justice system fit for the 21st century, and will take care that justice as we value it today will be justice that will be looked at in the future from a world perspective as a world leader. Thank you.
Thank you very much. I just remind members that there is some time in hand, although it's 6-minute speeches, interventions will be given back. John Finney, to be followed by Roderick Campbell.
Thank you, Presiding Officer. Lord Carloway described the Cadder judgment as a serious shock to the system, and others, perhaps unfamiliar with the protections afforded by the Scottish legal system, may have been shocked at the absence of legal representation for people who found themselves in custody at police stations. The Scottish Parliament responded to that, and we moved on. Now, Lord Carloway said, and I quote, "The task facing the review was to identify how criminal law and practice in Scotland should be recast to meet the challenges and expectations of modern legal thinking." And he said the focus in doing so would be applying a human rights-based approach. And if I perhaps touch on one or two of the key recommendations which cover that, legal advice is a right when taken into custody, period of arrest before charge limited to 12 hours, protection for child suspects and vulnerable adults, and no adverse inferences from the right of silence. These are fundamental changes that are proposed in this report, and clearly with that there's always a balancing act. Whose interests are being served and based on what criteria? Police investigations are clearly key to criminal matters, and I think the clarification of the end to the distinction between detention and arrest on suspicion I think is very helpful. I support certainly a robust application of a rights-based system. And that applies not only to what Lord Carloway has come up with, but to forthcoming legislation, which has been alluded to by a number of speakers. Now, I'd like to concentrate on a couple of aspects of rights there. Article 5, the right to liberty, and Article 6 on the right to a fair trial, and also to refer to them from the point of view of a very important informed user of the criminal justice system, Scottish Women's Aid. The emphasis is a presumption in favour of liberty. Well, that may seem self-evident in any system, but it requires saying and it requires to be regarded, and I'll refer to that later. Indeed, it has already, I think, been referred to by one or two speakers regarding the concerns Margaret Mitchell mentioned in relation to the release of accused. A letter of rights will be provided to every suspect who will be able to choose their solicitor. They'll be able to waive the right to a solicitor, and there'll be appropriate protections put in place for children and vulnerable adults, I think is very important. What was also alluded to is the training that will be required, not just for police officers, the Crown Office, Procurator Fiscal Service and solicitors, and that will bring about some consistency and comprehension over the role of each participant in the procedures. I think it's very important that if a suspect is charged, and this is an important right, that it should be brought to court within 36 hours of arrest. Again, that's been alluded to with the implications of that in respective courts, and I certainly don't see any problem with our courts responding to that by way of weekend sittings, public holidays, or, dare I say it, evening sittings. I think the additional clarification around a suspect being liberated for future questioning to give time for further investigation by the police is very important, not least in relation to issues around the forensic examination of computers and accounting systems. Yes, sir.
Lewis MacDonald.
I'm very grateful, and I recognise the point he makes about the potential for courts to sit at weekends and indeed on public holidays. Does he accept that there are resource implications to any such development, and does he believe that's something the government should consider in the course of considering these proposals?
John Finney.
Well, of course there are, but there's also the potential for greater use of technical equipment. And of course, what's important is we actually want to not increase the number of people going to court. We want to, A, deter crime, detect it, divert people away from prosecution. I want to quickly turn to the subject that most people have touched on, and that is the question of corroboration and the phrase from the Carloway-Report that evidence should be assessed, and I quote, free of the current restrictive rules and principles, such as the general requirement for corroboration. Now, that's a very simple phrase, but clearly with significant implications. And continuity of evidence which saw two people being involved in picking up abductions is nonsense and clearly isn't what most people are concerned about. What we must... Yes?
Christine Graham. Spinning out your time. Can you tell me, is there not a procedure in court where evidence can be agreed? So you don't need to have two police officers agreeing a label if the label is not contentious.
John Finney.
They may have to agree that the prediction has been jointly collected, so there's the implication right from word go. Yes, there's minutes of joint agreement can be agreed, and clearly they have their place. Scottish Women's Aid are clear to explore the implications of these proposals with regard to victims of crime who are experiencing domestic abuse. And we know the figures. I'm going to put them on the record again. 51, almost 52,000 incidents of domestic abuse, 10,000 ending up in court, and only half the cases reported to the fiscal reaching it to court. And the situation with rape and sexual assault worse. Recent Scottish Government stats show that the number of rapes reported is rising and the number of prosecutions failing. So clearly it's important that we do something there. Now, I think law and practice is evolving, and the Scottish Women's Aid refer to two important things that have helped that along the way, and that's the matrimonial homes legislation, and also citing a decision by Lord McCluskey in 1982 opening the door for a man to be prosecuted for raping his wife. And I think that's an example of how the law does evolve, and an example of how removal of corroboration could be seen in a positive light. The reality, again, with the question of Article 5, right to liberty, there's an understandable concern on the part of women that the alleged perpetrator of a crime is free to interfere with the household, interfere with evidence, get an alibi. But that's why it's important to realise that each case is individuals that are in it. That's individual victim, individual accused. And there is no one-size-fits-all in relation to all of those. Yes.
Margot MacDonald.
Presiding Officer, on the matter of no one-size-fitting-all, I'm intrigued as to why we're going for an end to corroborative evidence. Is it because we think that there will be a purer justice at the end of it? Is it to save money, or is it more convenient to pursue a case?
John Finney.
Well, the arguments have been about quality versus quantity, and just because you have two witnesses doesn't mean that they're necessarily reliable witnesses are going to be treated as such by the court, whereas you can have a very credible individual. I think we strive to maximise the evidence that's presented to the court at all times. That's not simply in terms of eyewitnesses, but all the evidence. So there's nothing that I understand as part of this that's a dilution of the investigation, which is to acquire the maximum evidence to present in front of the court. Yes?
Christine Graham, and then the member must come to a conclusion.
I just want clarification that corroboration isn't two witnesses. It's two independent pieces of evidence. It hasn't to be two people.
John Finney.
Yes, I recall that well from 36 years ago, learning it by rote. I do accept that. The Scottish Government is very keen that all these pieces of legislation are delivered in a coherent way. And the Making Justice Work programme is very important. So, in concluding, I would like to encourage everyone to participate in this in the short time that's left and give us their views. It's very important. Thank you.
Thank you very much. I now call Roderick Campbell to be followed by Malcolm Chisholm.
Thank you, Presiding Officer. May I begin by referring to my register of interest as a member of the Faculty of Advocates. As we all remember, the Cabinet Secretary asked Lord Carloway in 2010 to carry out a review of Scots criminal law and practice given the decision of the UK Supreme Court in HMA and CADA, and in the wake of the emergency legislation that followed. I would certainly hope that the Criminal Justice Bill, which follows the ongoing government consultation, contains provisions which will prevent the requirement for emergency legislation in the future. Carloway has a lot in it, however, apart from the proposal to abolish corroboration. There are important aspects in relation to arrest and detention, and I welcome the general support for the concept of arrest on reasonable suspicion. In relation to detention, the consultation seeks to test whether there is support, as I hope, for the proposal that the police would be required to consider the proportionality of holding a suspect in custody, taking account of the nature and seriousness of the crime and probable disposal if convicted. Carloway also recommended that questioning be completed within 12 hours. The principle of keeping detention without charge to a minimum should be welcomed and is a key aim of Lord Carloway's report. However, whilst welcoming that proposal, we must ensure that it will work. Some commentators suggest that it is an unrealistic period, and the consultation seeks to invite comment on it. We did, during a Justice Committee evidence session, float the idea of exceptions to it, and it will be interesting to see how the consultation goes on that. Additionally, Carloway recommends that charged suspects appear in court within 36 hours of custody. Whilst this is a laudable aim, we need greater detail on what that means in practical terms. For example, weekend court sittings, and further input from the government seems necessary, as Mr MacDonald perhaps hinted. The right to legal assistance. Carloway proposed including a requirement for legal assistance to a detainee as soon as practicable after the start of detention, regardless of whether he or she is to be questioned by police or not. Certainly access to sound legal advice is a cornerstone of a fair justice system, but we do need to consider whether there would be a sufficiency of solicitors to cope with the increase in uptake of legal advice if it were to become a statutory right, and how this is to be funded. Additionally, Carloway identifies a case for scope for the offer of legal assistance to be waived if detainees are fully aware of the consequences. That seems to be a fair proposal. With regard to children in the law, Carloway made an important recommendation regarding waiving access for those between 16 and 18, and recommending that those under 16 should never be allowed to waive their rights to do so. I hope we follow that path, even if there are those who argue that many children under 16 are mature enough to know their own mind. Presiding Officer, the Scottish Government intends to take forward Lord Carloway's recommendations on abolishing corroboration. I certainly have no issue with that. We do, as lawyers, seek to get round the rule by reliance on technical rules such as distress and the Moorhoff Doctrine. And I believe Lord Carloway was right to suggest that corroboration, I quote, has developed into a series of rules which realistically are not capable of being understood by many outside the world of criminal legal practice. And I do not believe that there is any substantial evidence that it does prevent significant miscarriages of justice, although clearly evidence is difficult to find. Nor do I believe that its abolition will necessarily lead to significantly larger numbers of successful prosecutions over the longer term. But however, I do think we must consider carefully the implications of abolishing it in relation to the remaining safeguards to prevent miscarriages of justice. I do not believe that by elevating the concept of cases needing to be proved beyond reasonable doubt, not only as our principal safeguard, but as somehow to a higher level, is either appropriate or sensible. In relation to majority verdicts, it's perhaps unfortunate that Carloway did not consider that within his remit, even if we have a good idea as to his views on the matter, so that we have not had any direct consideration of the impact of the abolition of corroboration on them. Although the Government does not believe there is any need to change the majority verdict rules at the present time, it would surely be wise to consider responses to the consultation on it, as indeed to the possibility of an additional safeguard that the trial judge should be entitled to acquit if he or she is satisfied that no jury properly directed could convict. Is it right solely to restrict this safeguard to the appeal court? I think we need to reflect further on that. In addition, while I share the Government's view that those who question whether the wider system of protections in Scots law is sufficient to prevent miscarriages of justice in the absence of a requirement for corroboration should put forward their evidence, I think it's important not to set the bar too high, to expect too much hard evidence in the same way there is limited evidence at present on how far corroboration prevents miscarriages. And the Government should accordingly take any well-argued concerns seriously, even if not fully empirically based. As to appeals and the role of the Scottish Criminal Cases Review Commission, whilst welcoming the recommendation to abandon what is called the gatekeeping role for the High Court in relation to SCC-RC references introduced by the 2010 Act in the wake of CADA, in relation to the new test proposed that it is in the interest of justice that the appeal be allowed, I do agree with Gerald Sinclair, the Chief Executive of the SCC-RC, in his evidence to the Justice Committee in December, that is not removing the gatekeeping role of the High Court at all, but, quote, instead to dismantle the gates at the bottom of the driveway and reassemble them at the entrance to the front door. I think the Government needs to look at that carefully. In conclusion, I welcome this consultation and I encourage anyone who has not participated to do so before the closing date. Thank you, Presiding Officer.
Thanks very much. I now call Malcolm Chisholm to be followed by Christina McKelvey.
Presiding Officer, unlike previous speakers, I'm sure, who are all justice experts in varying capacities, I read the Carloway report for the very first time over the last few days, and I have to say I found it very persuasive and set out with great clarity. However, I'm sure everyone is aware of strongly differing reactions to it, so I think it's very important that we hear all the views and acknowledge the complexities. Having said that, there are probably large parts of the report that are not too contentious, particularly in relation to detention, arrest, questioning and access to a lawyer. I, for one, very much welcome the changes that happened post-CADA, because we must always remember that some people who are arrested and charged are, in fact, innocent, and we must make sure that all our judicial processes are consistent with human rights. I'm pleased, however, that Carloway says that interviewing in the presence of a lawyer only needs to take place within a police station, because I know Scottish Women's Aid were concerned about interviews at the scene of the crime in their response to the initial Carloway consultation. Like Roderick Campbell, I welcome the suggestion or the proposal that detention should be limited to 36 hours, although clearly making that happen is going to be one of the challenges for the Scottish Government. I suppose I particularly support that because one of my constituents not too long ago was arrested in Edinburgh on Friday night, actually held in the cells in Dumfries until Monday morning, since there was no room in the Edinburgh cells, and eventually, in fact, his court case was dismissed. Like Margaret Mitchell, I note the concern of Scottish Women's Aid about police bail, so perhaps that has to be an option that is used very carefully, because clearly it would be useful in certain cases. In all my views on this, I have been very influenced by both Scottish Women's Aid and Rape Crisis Scotland, and I note, as I think is widely known, that both of those organisations do support the removal of the need for corroboration. Scottish Women's Aid emphasising the importance of the quality rather than the quantity of evidence, and Rape Crisis saying that it could make a significant difference, but crucially only if other action is taken as well. And I noticed at the Justice Committee, Rape Crisis suggested independent representation for rape or sexual offence, other sexual offence complainers, and I'm sure there are many other actions that need to be taken. So I don't think any of those organisations are saying that removing corroboration in itself will improve the situation, but it will help. And that view was taken by Professor Fiona Raitt at the Justice Committee, and I certainly found her evidence probably the most powerful. All the evidence taken by the Justice Committee at the end of 2011, and if members or members of the public haven't read her evidence of the 13th of December 2011 in the Justice Committee, then it is certainly well worth reading. She gave various reasons for supporting the abolition of corroboration, and the first was to do with sexual crime, and in fact she quoted very strikingly at column 6 to 8 on the 13th of December, something that Lord Hope said. She said, in a public lecture at the University of Edinburgh in 2009, Lord Hope of Craighead posed the question whether the demand for corroboration in circumstances such as those, and she'd been talking about sexual crime and sexual violence, might make us conclude that certain crimes in Scotland were beyond the reach of the criminal law. Of course, were that to be the case, it would not be fair or proper outcome of a modern justice system. So that was central to Professor Raitt, who, by the way, is a professor of evidence at Dundee University, evidence and social justice, in fact, I think. But she also made two other very relevant and interesting points. Firstly, that the criterion should really be a sufficiency of evidence, which is something quite separate and is not dependent on corroboration. And also, she made out, looking into the history of this, that corroboration has become eroded over the decades, that its application is often artificial and technical, and that its integrity is now discredited. So I found her evidence very, very persuasive, backing up what I'd already read about and heard about for a long time from Scottish Women's Aid and Rape Crisis Scotland. I give way.
Margaret MacDonald.
Presiding Officer, I apologise for not having written, or not having gone to the same resource that the member has. But did the Professor say what constituted a sufficiency of evidence? Is there any way to define it?
Malcolm Chisholm.
Well, I don't think I'm in a position to give an answer to that question in the 1 minute that remains to me, but I'm sure that you can read her writings, and there's various articles you'll find if you Google her name in relation to Carloway, and you can find those, and she's certainly written about that. So I believe that other changes can be made as part of the forthcoming legislation, but I don't personally think that they are directly related to removing corroboration. And the example that I would give in that category is the 8-7 majority on a jury. I felt very uneasy about that for a long time, quite irrespective of the whole issue of corroboration. And I certainly feel very uneasy about anybody, for example, being sent to prison for life on the basis of an 8-7 jury verdict. So I would be very happy if that was changed. Obviously, there's various ways in which it could be changed, but a minimal change could be 10-5, but obviously it could be more radical if people wish. Finally, where I do agree with Christine Graham, obviously I don't on corroboration, is in what she said in relation to the very last section of the report. I felt Lord Carloway let himself down on the very last page, because he suddenly said that the High Court should still have to look at whether an appeal being carried out was in the interests of justice, which seemed to me to be inconsistent with what he'd said in the previous pages, because it had this power gatekeeping, power post-cadre in case there were lots of appeals. But like Christine Graham and I think Roderick Campbell, I really don't see why they should have that gatekeeping role or something similar to it now. So that apart, and with the other caveats, I certainly welcome this report.
Thank you very much. I call Christina McKelvey to be followed by Michael McMahon.
Thank you, Presiding Officer. Presiding Officer, the presumption of innocence is the cornerstone of a just society and a fair justice system. Can I take this opportunity at this stage in the debate to thank all the organisations, Women Aid, Rape Crisis and others, to name just but a few, who have informed us in a very constructive manner during this debate and continue to inform us as we develop towards that fair justice system that we strive for. As we know, Lord Carloway published his report into criminal law and practice in last November. November 2011, he was asked to carry out the review after the Supreme Court ruled last October that evidence in the case of Peter Cadder was inadmissible, and he was questioned by police without a lawyer presence. The review is extensive, at over 400 pages, and includes 76 recommendations. The review held 77 meetings and carried out a public consultation receiving 50 responses. Investigation into jurisdictions elsewhere were also held, along with conferences and commissioning a research project for the Crown Office and Procurator Fiscal Service. A very robust investigation and analysis indeed. I did try to read it all last night to prepare for the debate. Lord Carloway argued that in incorporating the European Convention and ensuring that the correct rights-based approach, that there would need to be changes in the law and also alterations in the thinking of all of those working in the criminal justice system. I think we've heard some of that today from speakers previously. Presiding Officer, evolution of an effective justice system is essential, and this ties into what the Cabinet Secretary has said earlier in comments, that we need to have a longer-term review of our laws. They're an evolution, they're not just an event. I also see that mention is made of the need for training and guidance for police. Being a previous training officer in a professional capacity, I cannot understate that enough. The Crown Office and Procurator Fiscal Service, solicitors, everyone involved, bring in the consistency that John Finney mentioned earlier. This, I believe, you'll not be surprised, is a key task in ensuring that our key people are making sound judgments that affect the lives of people and the accused, especially the victims. As you know, effective training and continuous professional development builds a competent and confident workforce, and I believe that these underpin a very, very professional service. The proposals to give police increased powers to liberate a suspect from custody temporarily actually give me and others some cause for concern. These will be, of course, subject to certain conditions restricting their whereabouts and conduct and the possible negative consequences of this on women, children and young people experiencing domestic violence. Groups supporting people in the area of domestic violence have raised some grave concerns about this matter. I would ask the Cabinet Secretary to ensure that in this area that an effective risk assessment is undertaken of all accused persons to protect victims. On the issue of accused persons released on bail, Women's Aid have also expressed their concern that this will be further exacerbated by the numbers likely to be afforded temporary release. This matter is particular relevance in domestic violence incidents. It should always be the safety of the women and the people who are victims, especially the children, if this situation arises, and that in most cases the suspect should be detained if there is any risk at all of them further perpetrating any crimes. Women's Aid Presiding Officer further assert that there is an issue that such a blanket policy of release would also interfere with police investigations. I've heard from Margaret Mitchell and others today. And when the police investigations are at an early stage, sometimes that's when you pick up the key evidence. There could be an opportunity for someone, if they're released, to destroy evidence, to tamper with witnesses, to establish an alibi after the fact, and to intimidate and interfere. And we all know, as being members of the cross-party group Men's Violence Against Women, of cases where we've heard that's actually happened. You know, people getting phone calls, getting letters, getting Twitter and Facebook messages, you know, threatening them, and we should maybe be looking at some of that. Certainly.
John Finney.
Thank you, President Officer. I'm grateful for the member taking an intervention. The Women's Aid also commended the great strides forward in police treatment of domestic violence, and that would extend also to the application of this rule. Would you accept that, Yvonne?
Christina McKelvey.
I certainly would, and I would thank the member for his intervention, and I do make reference to that further on in my speech. It's okay. A further issue is how this process would be administered in terms of advising victims of a suspect's liberation, a matter of significant importance, especially in domestic violence, or where any violence is perpetrated on someone. Hopefully the Cabinet Secretary will give us some assurances on how this will work in practice. There can be nothing more scary for a victim than to see the accused on the street or back at their front door without even knowing that they have been released. On the issue of corroboration, which we've heard much of today, if corroboration is removed, it is vital that careful consideration is given to the introduction of new safeguards to minimise miscarriages of justice. We've heard a lot of that today. I have to put on record my support for the removal of corroboration for much the same reasons as my colleague Malcolm Chisholm has suggested. And Women's Aid agree too. They've said, and I quote, that there is a need to explore further the implications of removing the requirement for corroboration. However, in doing that, we should look not at what will happen if that is done, but at how we can make such a move work. And I think that is very, very important to remember that. As I said when I opened, the presumption of innocence is a cornerstone of a just society and a fair justice system, and John Finney referred to that earlier. But also John Finney referred to the number of incidents, especially of domestic violence. 51,926,000 incidents of domestic violence that police recorded in 2010. 10,259 ended up being dealt with in court. So the proportion of such incidents that reach court are relatively small. Only half of the 21,660 cases that were reported to the Procurator Fiscal made it to court. As is well documented, the situation with rape and sexual assault cases is even more worrying, and I know that the Scottish Government is working on this issue, and again, hopefully the Cabinet Secretary can update and reassure us that this is a priority for the Government. Within the remit of the cross-party group Men's Violence Against Women, we have concerns for many years on the role of corroboration, and hopefully we can work on fixing that, given some of the comments that they have said earlier. In the past few years, we've seen very welcome developments in the way police respond. John Finney will be happy to hear. In domestic violence, the approach to evidence gathering has broadened and taken a more forensic approach, adopting a more robust approach to investigation and presentation of evidence, a professionalism that I think is in the best interest of the victims and the accuser. There needs to be better conviction rates for rape, as we've heard from a number of speakers today, by using the rule of quality evidence. This may bring a sense of justice to the victims of such crimes. Indeed, the Cabinet Secretary had said earlier, when he informed us recently, that the Carloway Review has unearthed striking research in 268 of the 458 cases that were dropped in 2010 on the basis of insufficient evidence. There would have been a reasonable prospect of convictions if there had not been a requirement for corroboration. I think that's a very important point indeed. I would also ask the Cabinet Secretary to ensure that first responders are engaged in supporting victims of crimes, are adequately trained to identify victims of trafficking, which is one of the other issues. I see that I'm well over my time, Presiding Officer. I'll very quickly just finish up on 2 points. The introduction of greater support for vulnerable suspects is something that's very, very important to me. The letter of rights is welcome. On the issue of the one aspect of the review, actually, the Law Society agreed with Lord Carloway's recommendation is about child suspects. The Law Society suggests that safeguards should be put in place, being the age of 18 and the right to waive, not to waive consent. Could I ask the Cabinet Secretary to ensure that the children's hearing system indeed matches that with this proposal, in order to ensure that when we're talking about children in the criminal justice system, that we come from a welfare-based approach? The same again for vulnerable adults, and maybe a look at the appropriate adult scheme. I believe that a robust, fair and effective justice system is an evolution, and with these changes and commitments to certain safeguards, then we progress further down that path to a fair and just society.
Thank you very much. I now call Michael McMahon to be followed by Colin Keir.
Thank you, Deputy Presiding Officer. The American Supreme Court Justice Oliver Wendell Holmes once said, "This is a court of law, young man, not a court of justice." Now, that may have been his view from where he sat in relation to the American judicial system, but I'd like to think that anyone looking at or working within the Scottish legal structure would believe that justice is what should be pursued here at all costs. Now, I would never describe myself as having a high level of detailed knowledge in the ways of Scotland's legal profession, but I am keen to speak in today's debate as there are areas where I have a specific interest, So I welcome Lord Carloway's report, as it is an insightful commentary which I found very helpful in understanding some arcane aspects of the law. Although the Scottish Government has already responded positively to several of Lord Carloway's proposals, it's clear that some of his other proposals, which are currently being consulted upon, will require a lot more consideration given their more controversial nature. And not surprisingly, this afternoon's debate has seen most members focus on one of the more contentious of Lord Carloway's proposals, that of the removal of corroboration. Now, I believe that we must look at this objectively to arrive at a firm conclusion as to whether or not corroboration is suitable in modern-day Scots law. Now, while some will argue strongly that the principle of corroboration ensures that innocent people are not convicted on the basis of one person's oral evidence, some others will argue that if it's removed, then subsequent changes must be made to Scots law to preserve the integrity of the practice of the systematic use of evidence to convict an individual. And it's in this area of the conviction of people in Scots courts that I have a particular interest. And whatever opinion you hold on the matter, there are few people who would argue that the three-verdict system of guilty, and not proven is not a contentious one. Now, I'd like to thank the Cabinet Secretary for his recent letter to me expressing an interest in the outcome of my consultation on the three-verdict system, and I'm happy to tell him that I will provide the final analysis and any relevant information I obtain in order to inform his deliberations around that. But in the meantime, he may be interested to know that I've included in my Reform of Criminal Verdicts Scotland Bill proposal a document on mock juror studies that has established clearly that there is a relationship between the strength of evidence presented to a jury and the verdict delivered by that jury. Now, although we cannot categorically say what impact removing corroboration will have, evidence and studies show that it's highly probable that it will increase the number of not proven verdicts arrived by juries. Now, to mitigate such potential effects, additional measures would have to be introduced if the Scottish Government goes ahead with its plans to remove corroboration. Firstly, as has been said a number of times this afternoon, the majority of jurors that are required to reach a verdict must be increased from the simple majority that it currently is. In normal circumstances, a minimum of 8/7 would be required. Now, I do not have a definitive proportion of what this majority should be, but I do believe that no less than 2/3 of the jury should be required to reach a decision. And I invite anyone to give their views on this subject by responding to my consultation, which I currently have published, in which I seek an answer to that question. Now, by changing the threshold required for a jury to make a decision, the outdated three-verdict system that Scots courts use must too be done away with, in my opinion. If we stick with a three-verdict system, after increasing the majority, then it will be more difficult for a majority verdict to be reached, and it's highly probable that this will be controversial or unsatisfactory, and that an increase in the number of those types of verdicts reached in Scots courts. Now, I advocate the view that the three-verdict system in Scotland should thus be changed to a simple two-verdict system. Now, whether these two verdicts should be named guilty or not guilty, proven or not proven, or if different terms should be used and can be suggested. Sure.
Christine Graham.
I think it's very interesting. I wonder if the member can tell me, because I don't know, you may do through your consultation, how many not proven verdicts, for instance, over a period of time. Have you got figures for that?
Michael McMahon.
There are figures. I can't remember them off the top of my head, Ms Graham, but I can send you information on that if you would like. It is contained in my report, and I'll get information to you if it helps with your consideration. But once again, I welcome all the responses to this issue via my consultation, and would encourage members to look closely at it. If they have opinions, the more information I have, the better the consultation will be taken forward. Nonetheless, I believe that there are areas that must be reformed, with or without the removal of corroboration, and my Reform of Criminal Verdicts proposals details my views in that matter. If the removal of corroboration does go ahead, it has to go hand in hand with other changes which offer protections. As the Law Society of Scotland said, if corroboration is removed, it is vital that careful consideration is given to the introduction of new safeguards to minimise miscarriages of justice based on uncorroborated allegations. Now, I started off by questioning the views of Oliver Wendell Holmes, so I will conclude by agreeing with Sir Arthur Conan Doyle who wrote in the memoirs of Sherlock Holmes, "It's every man's business to see justice done." I think the Cabinet Secretary has brought an interesting debate to us. Lord Carloway's report certainly goes a long way to addressing some of the concerns I have around seeking justice from our judicial system. I think we move forward with the right resources and practical changes made, we can enhance our judicial system. And I think the debate that we've had this afternoon will obviously inform the outcomes that we can have as we move forward in that respect. Thank you very much.
Thank you. I now call Colin Keir to be followed by Sandra White.
Thank you, Presiding Officer. I think we've had some excellent input into this debate this afternoon. Since we last debated the Carloway Review, it's been clear that there's been much discussion within and surrounding the legal fraternity regarding the issues that have been raised. The fact is, these are times of change within the Scottish legal system, not just the Carloway Report, but it's been pointed out, reports from Lord Gill and his recommendations for reform of the civil courts, as well as Sheriff Principal Bowen's proposals for sheriff and jury reforms. Add to this the bill currently at stage 1 being discussed at the Justice Committee in relation to the Scottish Civil Justice Council, along with reforms in legal aid. It's understandable, given the scale of the changes being proposed at this time, that the legal profession are feeling a bit nervous. After all, how many of us like major change in our lives? Especially if you've studied and practiced for many years, as so many in the legal profession have done. All of these things within the Making Justice Work programme lead to some of the biggest changes seen in the legal profession in decades. And of course, as we've heard from a number of people in this chamber, including the Cabinet Secretary, the real headline act in this review is that of the future of corroboration. But there are some interesting reforms in the mix as well. Lord Carloway's criticism of the rules surrounding corroboration was severe, with him saying it had no place in a modern legal system. It's quite obvious that this view is not necessarily shared by everyone in the legal profession. I remember that Lord Carloway explained that in his view corroboration is a misunderstood term, and the important thing to recognise is that corroboration is about a number of witnesses there are to speak to a given fact. Later on in his evidence to the Justice Committee, he said, "We need to switch the thinking away from the quantity of evidence, the number of witnesses, to the quality of evidence." And I should say at this moment that it took Lord Carloway quite a bit of time within the committee to explain what corroboration actually meant. Now, in principle, I've got no problem. Surely quality should come before quantity when it comes to evidence. The fact that most, if not all, other legal jurisdictions have abandoned the need for corroboration should give some degree of comfort that the sky will not fall in should we abandon corroboration as a mainstay of prosecution. I do, however, have concerns that if we do move to a system where corroboration is not required, as proposed by Lord Carloway, then there should be more checks and balances, as in other legal jurisdictions, and I look forward to future discussions on this. This, of course, was also mentioned by Justice in their written submission last year. On the specific matter of rape cases, and I warmly welcome the comments made from some other people in this chamber, Christina McKelvey and Margaret Mitchell on this. I'm unsure myself whether or not the removal of corroboration will mean more convictions. I think it was Margaret Mitchell who mentioned the difference. Although I do take on board some of the comments, particularly by Rape Crisis Scotland in the written submission last December. Every one of the comments are worth discussion in the future. I also, as a caveat, agree with Christine Graham's comments relating to the fears about how victims and the accused behave in courts, the way individual people actually ask, because it is an important thing and may end up with problems in bringing forward a conviction. There's also the matter of whether or not victims are treated with more dignity within the legal system at present. Certainly, as Christina McKelvey has pointed out, there are serious problems within the issues of women in the court system. Some other issues raised are that of the clarification of the role of the SCCRC and the High Courts within this process, and they are subjects which are, again, worth more discussion before we make a final decision. And I'm very pleased to see that there is a mention of Saturday courts which have to come into the mix here. Certainly it will help with the issue of detention times, particularly over weekends. Back at the last debate, and I say this more to Michael McMahon, I did actually ask the Cabinet Secretary if he would consider the issue of the 3-verdict judgment within the parameters of the Carloway discussions, and I look forward to any information that Mr McMahon may bring forward in the future over this subject. Other issues I'm very comfortable with are in relation to those dealing with arrest and at what point you are required to be offered legal representation, as well as the time you can be held by the police. Again, the Saturday courts, I just think, is the way forward, and hopefully we'll be able to come to an agreement on that. I've already said on previous occasions that I warmly welcome the changes being proposed in relation to the way we deal with children and vulnerable adults. In fact, if you've sat through we had a discussion on, not quite on this, but very close to it within the Justice Committee, and there are some serious problems. It is something that once people head into the court system, they don't necessarily know or understand what's happening. I happen to believe it should be everyone's right to at least have that information, and I do believe that that is the way forward. The law and the process of law, of course, can be daunting to those involved at the best of times. Lord Carloway informed the Justice Committee that the reference group involved in the review was not asked to vote on the issues because there could be disagreement, so took the report in his own name. It would have been good to know the breakdown of views that were held within that group itself. As Lord Carloway pointed out when giving evidence, we live in the 21st century. The legal establishment today is a highly trained professional group, unlike, he suggested, most of those who practiced several hundred years ago. Unlike their predecessors, 21st century lawyers work in an interdependent legal system that must take account of international law, which of course includes the European Convention of Human Rights and the United Kingdom Supreme Court. So, Presiding Officer, I'm looking forward to seeing the results of the consultation paper. I encourage people in what little time there is left to be a part of that, to do so, and I will be supporting the motion this afternoon.
Thank you very much. I now call Sandra White to be followed by Helen Eady.
Thank you very much, Presiding Officer. Presiding Officer, well, so the motion before us is titled Public Consultation on the Carloway-Report Reforming Scottish Criminal Law. Most of the contributions have focused on the issue of corroboration, and I will return to this later in my contribution. Now, there are a number of aspects of proposed reform which I believe are generally welcome and accepted by all, and Cabinet Secretary had raised it and also other members as well. I mean, a simplified unitary system of arrest on reasonable grounds for suspicion and detention. An arrest will trigger a set of rights, including access to a lawyer. Any proceedings against a suspect constitute a fair trial, and suspects being charged should be brought before the court within 36 hours of arrest. And I know I do realise and note that the Cabinet Secretary did raise these issues in his contribution, and in particular that of legal advice and representation. And I can completely take on board the comments which were raised by the Cabinet Secretary and others in regards to the legal aid budget, an issue which the Justice Committee, which today I've just joined and became a member of, is looking at it, and I very much look forward to seeing exactly what is happening to the legal aid budget, and hope that justice will be served for the people who want to access legal aid through that particular budget. Now, returning to corroboration, Presiding Officer, many have said that our present rule is archaic and other countries do not have this, and we must move with the times into the 21st century. And yes, in some areas I do believe that we do have to change and move into the 21st century. Taking up John Finney's point about 2 police officers being needed to corroborate a label, I absolutely take that particular point on board, although I think Christine Graham's intervention seemed to make that particular aspect of John Finney's contribution slightly redundant. But whilst I do take the point on board, I am concerned, very much concerned, about the effects or the perceived effects of the removal of corroboration to the general public. Yes, I will.
Christine Graham.
It's just to clarify, I didn't say it made it redundant, but I did say that it could be agreed. But if it was contentious, of course you would need to have, you'd have to have corroboration. But items that are not contentious can be agreed, and it's encouraged that they're agreed in evidence.
Sandra White.
I thank Christine Graham for pushing that point even further, and I know that John Finney, I think, did accept that particular answer to the intervention, and I thank Christine very much for that. Now, as I was saying, that I do have concerns about the perceived effect on the general public of the removal of corroboration. And I do know myself that it just doesn't mention 2 witnesses being needed for corroboration. It's much deeper and more complex than that. And my colleague, Stuart Maxwell, I believe, is going to get into this particular issue in greater detail, so I certainly will leave it to him. But I do want to raise 2 particular issues which I dealt with constituents. It may have a bearing on the issue of corroboration, and I'll give you the 2 instances. A constituent reported by someone of alleged racial abuse. Police come to his door and the person is taken into custody and kept for 2 nights in a police cell. No corroboration, one person's word against another. Another incident I had was a lady actually arrested, supposedly alleged homophobic remarks, taken down to police station, questioned, asked for evidence. No corroboration, one person's word against another. Now, maybe, yes, I will.
John Finney.
Thank you, Presiding Officer. I'm grateful for the member taking an intervention. The member may not be familiar with the Moorhoff Doctrine, which is a system whereby a whole series of unrelated incidents corroborate themselves. So it may be that whilst that particular act may not itself be corroborated, there may have been a justification for the arrest in each of these occasions.
Sandra White. I thank Mr Swinney for the explanation. I was just putting it down to perhaps Strathclyde Police were particularly overzealous in these 2 particular cases. But I'll accept his explanation and look forward to perhaps Strathclyde Police coming back with the same explanation to both these incidents, which isn't just 2 incidents. There has been other incidents there as well. And I raise them simply because constituents have raised it with myself. And I think it's something we really need to bear in mind. Now, if I can just go and return to the issue of corroboration and return to Scottish Women's Aid's response to the consultation, I know a number of members have raised this particular issue. Now, I want to turn to page 11, 2.1. Should the requirement for corroboration be abolished? This is Women's Aid's response to consultation. They say, overall, we are undecided on this difficult matter, as there are compelling arguments for and against removing corroboration. I further go on to say that the arguments broadly, not me personally, this is Women's Aid's contribution, the arguments broadly in favour of removing corroboration refer mainly to the issue that is quantitative, numerical counting tests requiring the presence of at least 2 sources of evidence to assess sufficiency, as opposed to qualitative tests of these sources. They also go on to say, on the other hand, the case in favour of retaining corroboration states that abolition would require the fiscal to base their assessment of the success or otherwise of a likely prosecution solely on the basis of the complainer's evidence, meaning that fiscals will spend more time assessing credibility and reliability. Unintended consequences could arise in relation to the treatment of victims in domestic abuse and rape and sexual assault cases. Removal of corroboration, particularly in rape cases, would likely place a greater emphasis on their testimony, character, sexual history, medical history, etc., with the defence arguing that questioning has to be more robust and probing. Now, I raise these particular issues because obviously I think it's really important in this particular part, and I know that we are looking at a consultation, but these issues have to be kept and raised within that consultation. And in conclusion, Presiding Officer, can I also mention that whilst England and Wales have removed corroboration, conviction rates haven't risen. And I would ask everyone to please put forward their thoughts on this particular consultation. Thank you.
Thank you. I now call on Helen Eady to be followed by Stuart Maxwell. There's a little time for interventions. Thank you.
Thank you, Presiding Officer. I'm happy to speak in this debate this afternoon. I rise to speak to and support the amendment in the name of Lewis MacDonald, MSP. I declare an interest in that my oldest daughter is a senior deputy fiscal in the Crown Office Procurator Fiscal Service, and our youngest daughter is a trainee solicitor there as well, and both have many years of service. Presiding Officer, I have to ask why we are debating this issue now. Surely it would have been more appropriate to discuss these very important matters after the conclusion of the ongoing consultation. The Scottish Parliament should at least show all those who have taken the time to offer a response to this consultation the courtesy of considering their responses before offering its own views. I understand that at the launch of the Carloway-Report, the proposal on abolition of the rule and corroboration dominated the press questions, but in a report of 412 pages with 76 recommendations commissioned in the wake of Cadder, there is the wider remit of his report that also must command our attention. I agree with those professionals who say that we should certainly applaud his stated approach of seeking to incorporate convention rights in larger measure and at greater depth to re-establish Scotland at the forefront of law and practice of human rights in general. However, as Cameron Ritchie, the former president of the Law Society, said, he does not claim that his proposed reforms comprise a package which ought not to be cherry-picked. I understand too that the Sheriffs Association went one step further and suggested that the key reforms would mean consequences for a number of aspects of our procedure, and there are the financial implications. Such increased court activity may also not prove to be acceptable to a number of criminal justice participants, the judiciary, the Crown Office, the Scottish Court Service staff and security and the defence agents, and would place an increased burdens on both their funding and criminal legal aid provision. Therefore, it would be prudent to have further discussions on this matter with all the relevant parties and their representatives, and I hope these are meaningful discussions. But the consultation document warns that the move would have significant implications in the public purse due to an increase in legal aid costs, a question that the Cabinet Secretary himself agreed today. The Scottish Government cut the Scottish Court Service budget is a concerning move. So we need a commitment from the Scottish Government that additional funding will accompany any changes. The Scottish Court Service budget will be cut in real terms by 5.5 million in 2013 to 14, a total of 10.9 million, 14% between 2012 and 2013, and 2014 and 2015. As the Cabinet Secretary stated earlier, this in turn could have significant implications for legal aid in a time of reduced budgets, if such advice is to be publicly funded. On the issue of opening courts at weekends and bank holidays, the document warns that a pragmatism would be required to meet the 36-hour target. And video link technology conferencing is also mentioned in the document, and the Cabinet Secretary mentioned that this afternoon as well. We also know that during bank holidays and other times currently, Scotland's courts are open. And there is potentially more scope for cost to the Crown Office already severely stretched budgets. The Crown Office Procurator Fiscal Service own research found at least 600 cases of a serious nature from 2010 which would have proceeded under these proposals. This estimate was restricted to cases of a serious nature, but the proposals apply to all crimes. The Lord Advocate indicated that some cases which have not so far proceeded could be revisited in future. If the legislation is to be retrospective, this will, at least in the short term, greatly increase their workload. The research does not include those cases which have not been reported by the police due to their own assessment of lack of corroboration. The additional cases to be considered and prosecuted is likely, therefore, to be even higher. So the costs will be even higher. There are a number of relatively recent legislative and non-legislative developments which mean that each case requires significant additional work to be carried out. These include developments in the law on disclosure and in relation to the interviewing of suspects and the taking of biological samples. Legislative developments such as those in relation to vulnerable witnesses and admissibility of evidence lead to new procedures and additional work. Advances in technology and the increasing globalisation of crime add a fresh layer of complexity to criminal investigations and result in additional work. Also, challenges the compatibility of European criminal proceedings with the European Convention on Human Rights continue to be commonplace and require additional work in assessing the issue raised and in debate, which also impacts on court programming. More questions arise, for there are other professionals who raise interesting questions. In its consultation on the matter, the Scottish Government has invited views on a number of issues. Of particular interest is question 32. This question invites opinions as to what changes may need to be made to the Scottish criminal justice system if the corroboration requirement is abolished. Perhaps jury thresholds need adjusted, for example, as Michael McMahon has said. Very unusually, the question goes on to ask respondents for evidence to support their positions. This is more than just unusual. As Professor Robert Black QC has noted, this is utterly nonsensical. It is not possible to provide any evidence as such because corroboration has not been abolished, and so alternative mechanisms have not had to have been implemented. There cannot possibly be any direct evidence from the past about the effectiveness of untried future reforms. There is no use simply looking to other jurisdictions because their present systems do not exist against a background of a recently abolished corroboration requirement. There is no evidence which can be provided to support the introduction of measures designed to compensate for the abolition of corroboration. With many of the questions that have been referred to about Scottish Women's Aid this afternoon, I will not repeat them. I will simply agree with the great majority of them. But there is one issue that I don't think was raised, and that was the issue about the childcare aspect and the difficulties in the travel costs which may follow some of the changes that are envisaged. The reviews that have followed on from the publication of the Carloway-Report make valuable contributions to the deliberations on what progress is possible and taking these recommendations forward. I would just simply conclude by saying, Presiding Officer, that the utmost care must be taken to making sure that the financial costs are addressed so that if any changes are going to take place, they must be workable, they must be feasible, and cannot simply end up as something that's going to be undeliverable. The justice of the victim and the criminal is certainly at the paramount for all of us in this chamber. Thank you, Presiding Officer.
Thank you very much. I now call on Stuart Maxwell to be followed by Mary Fee.
Thank you, Presiding Officer. Can I begin by very much welcoming the Scottish Government's consultation on Lord Carloway's recommendations. His report covered a considerable number of areas, with the consultation containing some 41 questions, many of which are split into multiple questions. This is an important report with far-reaching recommendations on the possible reform of Scots criminal law and practice, and I would urge as many people as possible, as others have done, to submit their views to the Scottish Government before the closing date on the 5th of October. Given the breadth of the topics covered, I intend to deal with just some of the issues raised in the report, and I wish to start with the recommendations on custody. The recommendation to limit the maximum time a suspect can be held in detention prior to being charged or reported to the Procurator Fiscal to 12 hours is, I believe, a sensible one, as it strikes the right balance between the various parties involved. It provides time for the police to do what they have to do, but also puts pressure on them to do it timorously. However, in response to question 6 of the consultation document about whether there is scope for this time limit to be extended in exceptional circumstances, my view has not changed since the debate we held on the Carloway report back at the end of last year. I think there must be scope for the possibility of an extension to the 12-hour maximum time limit under certain circumstances. However, extensions must not become routine, and therefore I would ask the Cabinet Secretary to consider making any extension subject to an application to a sheriff, or by putting some sort of similar process in place. One final point on this issue is that I also support the necessity of a review of the period of detention after 6 hours by a senior police officer. I now want to move on to the issue of corroboration, an issue that has gained much attention and I think most, if not all, previous speakers have focused on. Lord Carloway's report discusses the requirement for corroboration and points out that it is not a requirement that every fact in a case has to be proved by 2 witnesses. As pointed out in the consultation document, Lord Carloway's report states that corroboration is about the number of witnesses available to prove facts. It is not about the number of facts available to prove guilt. The report then provides a number of examples of corroboration, but I just wish to focus on one of those examples, that of DNA. Lord Carloway's report points out that, and I quote here, a forensic sample can be the only evidence required to identify a perpetrator, but there must be 2 witnesses to A, the finding of the sample at the crime scene, B, the obtaining of a sample from the accused, and C, the comparison between those 2 samples. For me, this is the perfect illustration of why change is required. I think that most people believe that corroboration is about 2 pieces of evidence that corroborate each other, But in the case of DNA, corroboration refers to two people providing evidence about several facts concerning one piece of evidence. Certainly.
Christine Graham.
As a member knows, I probably don't agree with them, because I think the point being made about giving evidence in the DNA trail is traceability, to show that it is absolutely firm and secure that this is the DNA that was taken on the scene, that was then taken to the lab and is then produced in court. I think that's terribly important.
I don't disagree with Christine Graham that it's important. What I disagree with is whether or not it is required to be done in the current method that it is being done. But what this proves to me is that the world of criminal evidence has moved on, but the rules concerning Scots criminal law have not moved with it. Instead, the system has had to find ways of working around the rules on corroboration, as other members have mentioned, such as by having two people to speak to particular scientific evidence. A workaround is not and should not be seen as a cornerstone of Scots criminal law. Corroboration was an important part of ensuring fair trials in the past. It did provide accused persons with protection from the possibility of an overzealous system of justice, but the reasons for its introduction have passed into the history books, and so has the justification for keeping it as part of our system of criminal law and practice in the 21st century. Having said that, it's clear that we need to proceed with caution, as this proposal is a major change in the way our criminal law operates. The Cabinet Secretary will need to provide Parliament with a bill that answers many legitimate questions on this recommendation, and ensure that this change in no way unbalances our criminal justice system. Now, some people have argued, and we've heard it today, that if corroboration goes, then there must be accompanying changes in other parts of the system, such as relating to majority verdicts, and have called for unanimous verdicts or qualified majority verdicts to be introduced at the same time as any change to corroboration. However, I agree with Lord Carloway when he stated that there was no direct connection between the two issues. I think that some people misunderstand what happens in systems that require verdicts to be unanimous or by a qualified majority. In these other jury systems, a failure to arrive at a verdict does not result in an acquittal. The consultation document summarises the Carloway report very well on this issue, when it points out that if a jury is unable to reach a decision, the accused is not acquitted. Instead, a decision has to be made about a retrial. Scotland does not operate retrials in this way, and there are no hung juries. The agreement of 8 jurors is required for a conviction, otherwise the accused is acquitted. Yes.
Lewis MacDonald.
That the member makes. I wonder if he would confirm that. I wonder if the member would confirm that while it's true that his description of the English system is as he describes it, that there is no reason why the Scottish system, a reform of the Scottish system, would be confined to either the status quo or imitating jurisdictions elsewhere.
I absolutely agree with the member, and I'll come on to this, make some more comments just now on this very point, certainly.
Christine Graham.
I just want to remind the member that the terms of reference of Lord Carloway did not include a reference to the not proven or the current majority verdict. So he didn't really, it was not part of his job to consider corroboration within that ambit.
I'm very well aware of the report's reasons for being, and I certainly, however, don't accept that Lord Carloway didn't express a view on this issue in terms of, and as I said earlier, that he felt that there was no direct connection between the two issues. But if you just let me carry on this point, perhaps my view will be clearer. I think on the issue of acquittal in other areas of jurisdiction, this is a very important point, and I think it's one that's often overlooked by those who call for this change. In Scotland, you're either convicted or acquitted. You do not face being tried again under these circumstances. Therefore, whether we move away from a simple majority decisions on juries is not tied to any decision on corroboration. Instead, it is an issue that should be looked at on its merits. There may well be a case for a move to more qualified majority voting, but it's not reliant on the abolition of corroboration. The final point I want to make on corroboration is that the absence of the necessity for corroboration does not equate to the necessity of absence of corroboration. Just because corroboration is not required does not mean that corroboration will still form a part, and probably a large part, of evidence gathering in criminal cases. What any change means is that where corroboration is redundant or unnecessary in some way, it will no longer be a requirement. DNA evidence, I think, is a very good example of this. However, where it assists in proving a case beyond a doubt, I would expect that it will be continued to be used on a regular basis. In conclusion, Presiding Officer, I would quickly wish to support some of the other recommendations contained within Lord Carloway's report.
Very quickly, please. You're well over time.
Regarding areas such as liberation from police custody and investigative liberation, child suspects under 16 being unable to waive their right to legal advice, and that rules concerning vulnerable adult suspects need to be placed in statute. Finally, can I welcome the fact that the Government is moving swiftly on these recommendations, and I would urge it to do the same with another area that has been the subject of an SLC report, namely the use of previous convictions under certain circumstances.
Excellent. Many thanks. Now call on Mary Fee to be followed by Stuart Stevenson.
Thank you, Presiding Officer. I was eager to speak in today's debate to highlight concerns that I have with Lord Carloway's recommendations on arresting and detaining a suspected offender. I've spoken many times in this chamber about the need for a uniform approach to the forgotten victims of the justice system, children. I was pleased to see, and I welcome the recommendations that Lord Carloway gave on child suspects. However, I was disappointed that children were not mentioned in any of the recommendations about arrest and detention. Scotland is sadly lacking behind many of its counterparts when it comes to this area. Poland and many jurisdictions in the US have police protocols for arresting a suspect in the presence of a child. According to a study carried out by the University of Illinois in the US, when a child witnesses their parent's arrest, they often feel anxiety, suffer post-traumatic stress, and feel scared because nobody has explained to them what has happened and what will be happening. Not only that, witnessing a parent's arrest can have a different effect on the child depending on what age they are and what stage they are at in their development. Many of you in the Chamber might not know, but last week the UK published its response to the United Nations Universal Periodic Review of Human Rights. One such question was to ensure that the best interests of the child are taken into account when arresting, detaining, sentencing or considering early release for a sole or primary carer of a child. This recommendation was welcomed by the UK, and being part of the UK means that we need to ensure that this is taken into account. While I welcome many of the recommendations that Lord Carloway gave, there is not one mention in all of his proposals on arrest and detention about the rights of a parent and a child. I feel that if changes are going to be made to arresting and detaining suspects, then the rights of the child should be taken into consideration as well. Even simple things like allowing the parent to arrange someone to care for that child whilst they are being detained, or even taking children into another room when the parent is arrested, can make a huge difference to the child. This will minimise disruption and unnecessary trauma to the children by providing the most supportive environment possible during and after arrest, and also cut down on the intergenerational reoffending. Whilst I feel that the review is lacking in its recommendations of arresting and detaining suspects, I do agree with Lord Carloway that corroboration should be abolished. Corroboration is an ancient and archaic law that is preventing justice being served on some of the most heinous crimes, such as rape and serious assault. Judges and juries should be free to consider all relevant evidence and answer whether they are satisfied beyond reasonable doubt that the accused person committed the offence. By abolishing this outdated rule, it will bring Scots law up to date and in line with many other countries on how to approach evidence. However, if corroboration is abolished, I will say that it is vital that careful consideration is given to the introduction of new safeguards to minimise miscarriages of justice based on uncorroborated allegations. As many of my colleagues have already pointed out in this debate today, research carried out by the Carloway Review Group found that if corroboration was removed, 81.7% of rejected cases in 2010 could have proceeded to trial with a reasonable prospect of conviction in 58.5% of cases. Yes, certainly.
Christine Graham.
I mean, I may accept that they might have got as far as the court door, but to say they have a reasonable prospect of being successful, I don't see how that can be said when it's never been tested. because we'll be back to juries or the sheriff looking at credibility. And you can't prejudge that. You'd actually have to run the cases to find out.
Mary Fee.
I thank the member for her very knowledgeable intervention, and I need to take advice. Obviously, it is very much a grey area, and we can only speculate on what may happen, and I can only work on the figures that were in the review. In 2009 to 2010, 276,000 prosecution reports were submitted to the Crown Office and Procurator Fiscal Service, of which 242,000 were submitted by the police and involved 278,000 people. When corroboration is removed, there will be many more court cases and many more offenders in prison or serving community sentences. Scotland's prison sector is already overcrowded, and by 2019-20, the number of prisoners is predicted to hit 10,000. The abolition of corroboration will result in more convictions and consequently more prisoners. It will also mean that more cases will make it to court, and I was therefore surprised at the fact that the Scottish Government is looking to close many sheriff courts and Justice of the Peace courts. If corroboration is removed, then it will have an impact on the work of the Crown Office and Procurator Fiscal, as well as the Scottish Court Service and the prison sector. With having fewer courts to prosecute offenders and taking into account the extra distance that victims, witnesses and the accused will have to travel, which will make it more difficult for people to attend court, then this will threaten to cause more delays and disruption to cases. This does not seem to be the time to close courts, while taking away a rule that has seen so many cases in the past rejected for trial. Couple this with a budget cut of a total of £10.9 million over the next 3 years that the Scottish Government has just announced, then we could be looking at serious delays and disruption to many court cases. Cases will be rushed through because of the backlog, and many people will not receive the justice that they deserve. Whilst I still agree that corroboration should be removed from the Scottish legal system, the Justice Minister needs to look at the implications that this will have on the courts and prisons, or else we could be looking at having many cases being delayed and the prison system being overcrowded. If some of the proposals mentioned today are enacted, then we could be looking at crisis in the courts and prisons in the years to come. Our justice system does need reform, but that reform must be done with care and consideration, with the protection of the vulnerable at the forefront of that deliberation. Thank you.
Thank you very much. Now calling Stuart Stevenson, after which we'll move to closing speeches.
Thank you, Presiding Officer. The Cabinet Secretary said in the debate in this place in December, the status quo is not tenable. We have to make changes, and therefore it's important that we set the tone by showing, as we have done today, that's December, that this is about having a discussion and debate with the legal profession and the general public. And I think today's debate, wide-ranging as it is, has maintained a proper tone to help us all be better informed as we move to further discussions on this. I very much welcome the opportunity to return to justice debates. I served in Session 1 on the Justice 2 Committee and in Session 2 on the Justice 1 Committee. With a major prison in my own constituency, I've taken a close interest in the penal system, visiting prisons in Peterhead, Porterfield, Saughton, Polmont Young Offenders, La Bapaume near Paris, Park Prison in Wales. I've visited sheriff courts at Dornoch and Glasgow, and I've served on a jury 30 years ago at Linlithgow Sheriff Court, and indeed I visited Carstairs on one occasion, the Hospital for the Criminally Insane. None of that makes me an expert. I'm surrounded by a lawyer, a policeman, a QC and another lawyer, all who have spoken in the debate and have expertise to which I'm not even going to try and aspire. I'm merely, as Rumpel of the Bailey might have said, an old Bailey hack. I'm an old Parliament hack in matters like this. We do know that justice operates very differently in other countries. In 2006, when I was across on 2 occasions in Georgia, in the Caucasus, under the sponsorship of the Westminster Foundation for Democracy,
running courses for local political parties and how democracy worked, I had the opportunity to meet the Georgian Justice Minister. And his great claim to fame was he'd put 3,000 more people in prison and reduced the time it took to be in the queue to get into the prison to visit your relatives down from a week to 3 days. A very different environment from the one which faces us today. I think I might start by saying that it is obvious that not every customer of the system is entirely satisfied. And I say that both from the point of view of the victims and, of course, those who are being prosecuted. Indeed, in coming down to Parliament yesterday on the train, in the seat behind me, I had an animated conversation between someone who is clearly a criminal. He's just broken the terms of his parole and he thinks he's going down for 4 years. His chum trumped him. He said he's up on an attempted murder out on bail. I didn't attempt to engage them to get more details. I thought that might not be the thing to do. On another occasion, I was in a cell in Saughton as a day visitor with six murderers hearing their stories. And one of them was complaining to me that just because he'd been released on still in his life sentence, he'd been released, he'd been recalled simply because he'd been present at another murder. So he hadn't committed it, he'd only been present, and that really shouldn't have counted. So therefore, some of the things that we hear about the criminal justice system and its operation are things we probably are going to discount significantly. But we shouldn't imagine that we have a perfect system. It is necessary that we look at the system. It is necessary that we seek ways of improving it. Several contributors to the debate have touched on ways of allowing people to appear in court, to appear before a sheriff without necessarily being physically present, using television, using other ways of getting to court. And I think that's absolutely the case. Many of the processes that we have are very much by rote and don't obviously contribute to justice. When in the Justice 1 Committee we visited Glasgow Sheriff Court on a Monday morning, we were in the court for an hour, sitting in the jury box, which was not being used, and we saw 59 appearances being dealt with in a single hour. And we were left pretty baffled as to how any of this contributed to justice. So I think ways in which we can avoid having to aggregate lots of people in one location using modern technology is something we certainly should look at. Now, on my appearance as a juror in Linlithgow Sheriff Court some 30 years ago, listening to the issue around corroboration, the discussion of evidence that we've had today, it does strike me that now evidence is a much more complex and diverse issue than it was, say, 100, 150 years ago. One of the things that happens, of course, and I found in the 2-day trial I was on a jury, the sheriff was absolutely first class in his summing up and explaining what was expected of the jury, showing the tests that we might apply to evidence in considering whether the guilt or innocence of the two accused who were in front of us, what verdicts we should come to. But I can't help imagining that really, with the increased complexity, the sheriff might usefully have told us before we heard the evidence the sort of tests we might have been thinking about as we heard the evidence. When it's a 2-day trial, you can think back. I had a professional colleague who was once on a trial that lasted 4 months, trying to remember what happened 3 months ago. Well, I can't remember what happened last week most of the time. And I know that I'm not alone with some of those of us who are of an age. Now, on corroboration, and I will bring my remarks to a conclusion as soon as you nod more vigorously, Presiding Officer.
1 minute.
I think, thank you very much. That's helpful. 150 years ago, we were looking very much at remembered evidence. The evidence of what people saw was reported to the court. Now, very often, we're looking at evidence that is recorded evidence. Technology has provided the evidence. The character of it is quite different, and the way we should judge it is quite different. It's 110 years since the first person was a victim in the criminal justice system of the benefits of dactyloscopy, in other words, the science of fingerprint recognition. From that point onwards, science became part of the evidence base. We may not yet have fully caught up with everything that came on. Michael McMahon, I very much am interested in his efforts on the 3 verdicts, but let's abolish not guilty and keep not proven, because it's the older verdict. Incidentally, in my Sheriff Court appearance, of the 14 charges there were, we had 7 not provens, 5 not guilties and 2 guilties. So juries are quite capable of dealing with it when they have the evidence. Presiding Officer.
Many, many thanks. We now move to closing speeches. I would remind all members who have taken part in the debate they should be in the chamber. I now call on Annabel Goldie. A generous 6 minutes, please.
Deputy Presiding Officer, thank you very much indeed. This afternoon's debate has been interesting, if somewhat familiar. Last December, this Parliament debated the recommendations contained in the Carloway Review, and 9 months later, the Scottish Government has still failed to advance the debate, because we are now considering a consultation which largely replicates the recommendations in the report, despite extensive criticism surrounding the proposed end of corroboration. And while, as the Cabinet Secretary indicated, it is understandable that the controversial proposal to abolish corroboration has been the focus of comment and debate during the past few months, another important element has been overlooked, and that is that the review's recommendations relating to arrest, detention, custody, investigation and the interrogation of suspects all go to the very heart of compliance with the European Convention on Human Rights. So we must do all we can to avoid the situation which arose out of the Cather case, where this Parliament was forced to debate emergency legislation to ensure that Scots law complied with basic human rights. That failure lay with the Scottish Executive of the time. It did not, as the First Minister and Cabinet Secretary have suggested in the past, lie with the Supreme Court. But there is, however, very clearly a debate to be had surrounding the abolition of corroboration, and one only has to listen to the contributions from the Chamber this afternoon, including, I may say, encouragingly, from some of the backbenchers of the SNP. Now, abolishing corroboration might mean more people can be prosecuted. That does not mean more people will be convicted. And experience has suggested that where the burden of proof is reduced for the prosecutor, reasonable doubt may loom larger for the jury. And if a jury is in doubt after hearing all the evidence, because non-corroborated prosecution evidence is simply denied by the accused, it will acquit or find not proven. And I have to say, I thought Christine Graham made both a very robust and courageous contribution, if I may say so, in that respect. Can I just say, in support of that point which I've just advanced, I remember in this Parliament the Review of Sexual Offences published in 2006. It made 50 recommendations designed to improve the investigation and prosecution of rape and other sexual crimes. And all 50, including a number in decisions to prosecute and evidential requirements, were implemented by the summer of 2009. And convictions for rape and attempted rape still remain very low. Indeed, they were at their lowest level in 2010-11, when the proportion of reported rapes and attempted rapes, those reported, the proportion of these leading to conviction, was 3%. Now, a number of contributors have rightly signalled their concerns, Colin Keir and indeed Sandra White, and I do urge a Cabinet Secretary to listen very, very carefully to these concerns. It is also the case that if a jury does convict, an equally alarming consequence of abolishing corroboration is the prospect of miscarriages of justice, particularly if, as some members have indicated, related aspects of Scots criminal law are not also considered. And indeed, the SNP has undergone something of a change of heart on this issue, because the Cabinet Secretary now describes corroboration as a rule that stems from another age and appears hell-bent on abolishing it, regardless of what the experts say. But I have to observe that this is the same individual who thought it appropriate to claim that 2 of Scotland's most senior and universally respected judges in the Supreme Court had gained their knowledge of Scots law through visits to the Edinburgh Festival. And the Cabinet Secretary has previously castigated the Cara decision as one which, and I quote, overturns decades of criminal procedure in Scotland, a proud, distinctive justice system developed over centuries and predicated in fairness with many rigorous protections for accused persons. Bold, stalwart words which I entirely support. The irony is mocking that by rigorous protections he was, of course, referring primarily to, yes, corroboration, a principle of evidence he robustly supported when lambasting the evil Supreme Court. Deputy Presiding Officer, the Law Society of Scotland, the Faculty of Advocates and Justice Scotland have all warned against implementing the corroboration recommendation in isolation. And this isn't about the establishment resisting change. This is about effecting change which makes things better, not worse. This is about getting a major change to our criminal legal system right and not reforming it in a higgledy-piggledy, illogical fashion. And I have to say that removing corroboration without seriously considering other safeguards against miscarriages of justice would not only, in my opinion, be dangerous, but it would also be a missed opportunity to consider related matters. Some of these have been referred to this afternoon. Majority verdicts, burden of proof in criminal cases beyond reasonable doubt. Should Scottish judges be able to warn a jury about the reliability of a single piece of evidence, as is the case in England and Wales? What about the not proven verdict? Now, these are questions which have only been given passing consideration by the Scottish Government's consultation. It is perhaps unsurprising that Lord Carloway did not recommend a full-scale review of Scottish criminal procedure. That was not his remit, as Christine Graham quite rightly observed. But I think abolishing corroboration in isolation is causing widespread unease. Unease clearly shared by members of this Parliament across the political parties. We know that in December of last year, the Justice Committee convener Christine Graham listed no less than 7 concerns she'd heard against the removal of corroboration without wider reform. Stuart Maxwell has called for a debate on majority verdicts. Colin Keir has said now is an appropriate time to re-examine the 3 verdicts. And nearly a year on, it is worrying that the Scottish Government has failed to listen to such, I think, legitimate and reasonable concerns, and many have been echoed by his own colleagues during the debate this afternoon. Now, Deputy Presiding Officer, while I appreciate the Cabinet Secretary wants to press ahead with the useful reforms proposed by Lord Carloway, I urge him to exclude corroboration from the forthcoming Criminal Justice Bill. It needs to be part of a wider debate, and it needs to be informed by the very sort of evidence which Mary Fee, to her credit, confessed she didn't have, and which Christine Graham quite rightly indicated is an essential part of informing this debate. For that reason, Deputy Presiding Officer, I must say I found the debate genuinely interesting, but I do support my colleague Margaret Mitchell's amendment.
Many thanks. I now call on Jenny Mara, a generous 8 minutes, please.
Thank you, Presiding Officer, and it's a pleasure to speak in this debate this afternoon on all these very, very important issues in the landscape of Scots law and evidence. And I think at the moment, certainly in this Parliament, we're being asked to consider perhaps some of the most far-reaching reforms to Scots law, and it's very important that we debate this well and often and get these changes absolutely correct for everyone involved in the legal system, and not least the victims of crime in this country. I'd like to start with looking at the debate this afternoon, because I think there were many informed and some very learned speeches raising extremely good points that I hope that the ministers will consider in the closing speech, and that we all should take forward to committee and to the following debates on this issue. If I could refer to Roderick Campbell's speech, I was hoping to intervene on Mr Campbell, but actually didn't want to, because he always makes a very learned speech on these issues. But I wanted to pick up on a point he made very early on in his opening remarks regarding Cadder and the emergency legislation that this Parliament had to consider as a result of that judgment, and Annabel Goldie picked up on this point as well. I think one of the proposals that Labour put forward in its manifesto last year was a full audit of Scots law to make sure that the law in our country is ECHR compliant, and that kind of full-scale audit would prevent scenarios like the emergency legislation that we faced in the wake of Cadder, because we actually could argue that looking back over the series of... Yes.
Cabinet Secretary. Quick point about the Cadder judgment. Could you tell me how an ECHR review would have affected the position given the decision taken by the High Court of Appeal in HMA v McLean? Is he suggesting that our review could have overturned a High Court bench? Jenny Mara.
No, I'm not suggesting that, Presiding Officer. I'm suggesting that we actually need to look forward and look at our Scots law with view to ECHR, because Cadder wasn't the first time that Scotland had heard of the problem with the Section 14. There had been the Saldus case a few years earlier, which would have given the Parliament a bit more time to prepare and not have to consider emergency legislation. So I hope that that audit is something that the ministers may consider in this whole-scale look at Scots law. There were many other very thoughtful contributions. Roger Campbell also made points about the resource implications of the Carloway proposals in front of us. Christine Graham drew Parliament's attention to the fact that we must consider the majority verdict in our considerations of this. Malcolm Chisholm made a very good speech pointing to Professor Fiona Rait's work on the sufficiency of evidence in this debate, and I think that we will all go and look at Professor Rait's comments in the light of Malcolm Chisholm's speech today. I think it's also worth noting, I understand that Professor Raitt has made a call for a whole-scale review of the law of evidence, and I think that is certainly something that the ministers might want to comment on as well, because to look at this in a piecemeal fashion is perhaps not serving the system properly. Mary Fee's remarks, very welcome remarks for children. I think children are people whose voice is often drowned out in these debates on Scots law, but she makes powerful advocacy for their rights within the legal system and under these proposals. But I'm glad that the Cabinet Secretary has taken the time to bring this motion to Parliament. I think it's important to debate these proposals often and well. And we have seen today from this debate that there are still many questions to be answered on the Carloway review and how it is implemented. While generally supportive of many of Lord Carloway's recommendations, it does strike me as a little curious that the Cabinet Secretary bring this debate to the Chamber before the consultation has even closed, without that evidence offered to him by legal experts across this country, but it is a good opportunity nonetheless. It's clear to me from the contributions this afternoon that there is a detailed consideration and further debate to be had about how we can effectively implement Carloway's recommendations. And I believe that full engagement with stakeholders is a very necessary part of that debate. Because the end of corroboration in Scots law would be a major shift, not only in the way that verdicts are reached in our courts, but also in the number of cases that will reach our courts in the first instance. And it is vitally important that we have the foresight to envisage what impacts its removal would have on our legal system. We have also heard contributions today that the pressure put on our court services, both in terms of their budget cuts and the proposed closures of sheriff courts around this country, would undoubtedly have a bearing on their ability to undertake a much bigger caseload. And from this perspective, I would ask the Cabinet Secretary to fully consider the consultation on the future of our courts, not just through the lens of the challenging financial situation that he faces, but also through the lens of promoting effective and speedy justice for victims of crime that Carloway recommends. Because I'm in no doubt that limiting the number of jury trials too much, closing too many courts, could have an adverse effect when the recommendations of Carloway are implemented. We have heard today of the complexities that surround the proposal to make corroboration retrospective in its application. Not least, this would have the potential to put our police services and our fiscal service under considerable strain to deal with an increased caseload and a reopening of cases that did not come to trial in the first place. As has been mentioned, 58.5% of cases in 2010 that did not go to trial because of insufficient evidence would have a reasonable chance of conviction if the need for corroboration were removed. Yes.
Annabel Goldie.
Can I just test the member's presumption? I produced in my contribution evidence which showed that significant changes to how we are prosecuting rape, attempted rape and sexual offences has not actually led to an increase in convictions. So how can the member assert that simple abolition of corroboration ensures that there are more convictions?
I don't think that's exactly what I did assert, presiding officer. I think what I'm saying is we need to look at things in the round to make sure that we are getting more convictions, and we need to look at the proposals for corroboration very carefully to see what impact that they would have. Because I think today, similarly, we have heard of the need to consider these changes within the wider context of access to justice, where Christine Graham eloquently outlined the remit within which Carloway has operated. And I think she gives the government good cause to think carefully about the proposal from my colleague Michael McMahon, who has quite rightly taken a broader view of criminal justice to include a debate about the verdict of not proven. Presiding officer, these are just a few of the questions that the SNP must face up to if they are serious about bettering our criminal justice system. The principles underlying Carloway's recommendations are good ones. They are based around the rights of victims and witnesses to speedy and efficient justice, and they lay their roots justifiably in human rights legislation. But to have a fully informed debate about the virtues of the report, we must look to include the voices of all interested parties from all corners of our justice system. And we must also look to include a holistic assessment of the criminal justice landscape, including Michael McMahon's proposal for reforming the verdicts that can be reached in jury trials.
I now call on Kenny McCaskill to wind up the debate. Cabinet Secretary, I would be obliged if you would end at 5 o'clock.
Thank you, Presiding Officer. Can I say I think this has been a very good debate, very wide-ranging. There's some contributions that I thought were excellent indeed, and I'll return to them. I think perhaps the first point to make is some point was made about this being premature, and the timing was raised by Helen Eadie. Can I give an assurance, as I did mention to Lewis MacDonald, this is not at the end of the process. There will require to be further discussion and debate, especially given safeguards that we've commented on, and the bill will be subject to full parliamentary scrutiny. Equally, I did take from Annabel Goldie's closing remarks that she was critical that we had been dilatory in not having moved matters apparently fast enough since a debate in November last year, and equally she then seemed to close on saying that we were going too far too fast. Doubtless, as ever, the truth is somewhere in the middle. Can I say, with regard to the speeches, I thought Rod Campbell made an excellent speech in which he pointed out not simply the corroboration that has, I think, understandably, not been not simply externally but internally in the Chamber being the basis and focus of matters, but commented on the other significant matters that are required to be considered and addressed. There are many, and we'll have to come back to them, but he did, and I think others pointed out, the issue of police bail. Lewis MacDonald himself commented on that. That is something that we need to look at significantly. Clearly, Lord Carloway has put forward proposals. There are safeguards already in how we currently operate bail. Does give the opportunity for the fiscal to move forward and the court to grant bail on strict conditions and a whole variety of matters there. But whether it's in terms of dealing with the victims of domestic violence or other aspects, I think we have to make sure that we get these circumstances right. So, as I say, I think I can give an assurance to Rod Campbell, who correctly raised the other aspects, not simply corroboration, but indeed to Lewis MacDonald, who raised that particular matter, that we agree that it is a matter that we'll have to look at carefully. But I do believe that there are sufficient checks and balances initially in the system that we do recognise as a chamber over many years, and indeed it's subject to a matter that's commented on frequently and indeed changed in terms of policy directions by the Crown about what advice and guidance is given on police bail and other matters. Equally, the SCCRC was also commented on. That's a matter that we have to also look at. It was touched upon by some, especially the matter relating to the interests of justice test. But I would refer people to the point, I think, correctly being made by Lord Carloway with regard to that, where he was anticipating matters where I think people were perceiving this as the gatekeeper once again being given to the High Court to close matters down. Can I refer people to the evidence given by Lord Carloway to the Justice Committee? Lord Carloway stated that he sees this test being applied in situations such as where the High Court receives new information about a case. This new information could either not have been included in the SCCRC review reference or may have emerged since the reference. So I think rather than seeing this as some duplicitous act, we should see that what Lord Carloway was seeking to do was to assist the SCCRC where matters may have further come to light. So as I say, I think we should look more closely at the evidence that was given. So as I say, by all means.
Christine Graham.
Regrettably, I don't have the challenge that was then made to Lord Carloway on that, but I know the committee challenged him on that very point and took him to the area where it still means it leaves it to the High Court, notwithstanding everything, when there's been a miscarriage of justice, to come out with the line, it's not in the interest of justice, however, to allow this appeal. That cannot be right in principle.
Well, I think what we have to do is to look at this matter in the round, which, as I say, I think it's why it was appropriate that Rod Campbell should have mentioned that there were other aspects, not simply corroboration. I do think that what Lord Carloway was seeking to do was to assist matters where new evidence may have come to light that could not have been available there. Equally, that is a matter that this chamber, Ms Graham's committee and others will doubtless look at. I just thought it important that we should put on record where matters were with regard to that. Clearly, though, as with debate externally, the focus has been on corroboration. I think there's perhaps three things we should first look at. Why do we have a corroboration in Scots law? What has changed? And indeed, if we are to make a change and abolish corroboration, what safeguards require to be given? Well, I have to say, with regard to why we have corroboration, I think that was a matter mentioned by Margot MacDonald. I have to say, when I asked Lord Carloway, I think it's mentioned in his report, he indicated that as far as he could see, it goes back to Romano-canonical law. Now, it's not for me to criticise Romano-canonical law. I think it's the basis of many jurisdictions. It's doubtless been of a great support in providing all these matters, but that's where he says it comes from. Now, as I say, civil law that we have practiced is in many ways based upon aspects of Roman law, and Scotland has benefited from that. But there's no clear basis from which it came in, but it came around at those times. But by all means.
Annabel Goldie. I'm very grateful to the Cabinet Secretary for outlining to the Chamber the eminent origins, the genesis of this important principle. But if it was rubbish, as in his opinion he seems to think it is, why has it endured for so long?
Cabinet Secretary.
I don't think I've ever suggested it was rubbish, and I think Annabel Goldie denigrates matters here. I do think a valid point was made in the debate by Stuart Stevenson. Matters have changed, and I think we have to look at that. We had corroboration at a time when it was mentioned. I think the lack of education and legal expertise for some of the judiciary was different from what it is now. We didn't have DNA when you have certainty, to the millionth degree or whatever else. We didn't have video evidence when people are clearly positioned there. So the world has changed. So these matters require to be taken in that round. In terms of the point being made by Margot MacDonald about what the basis behind the intention to remove the rule of corroboration, the intention is to enable the best evidence to always before the court, so that its credibility can be assessed there. As Lord Carloway stated, corroboration can be seen as an archaic rule, and we want to focus more, and it was mentioned by John Finney, on the quality rather than the quantity of any evidence. So, as I say, it has served Scotland well. Equally, Annabel Goldie will recall that when I was going through university, and this was viewed as one of the gold standards of Scots criminal law, the other matter that I recall was the 110-day rule. Now, the 110-day rule has gone. Scottish law has not collapsed, but we have actually moved into the 21st century and recognised that some changes need to be made. So, as I say, I think we have to put in context why we have corroboration, what has changed, but equally the point has been made by many speakers and it is accepted by Lord Carloway, but he didn't think it was appropriate for him to bring that in, but we accepted as an administration that there do require to be safeguards. Obviously, the primary matter raised, and it was mentioned by Michael McMahon, which is why we have been in communication with them and are happy to take on board the valid work that he's already done, and we're very grateful to him for that. The verdict does have to be looked at. We're not going to prejudge what may or may not, as I say, be the outcome of that, but I do accept that it's a valid situation that has to be looked at, and I welcome the contribution he has made today, the contribution that he has made in terms of his consultation, and we look forward to being able to build on that. By all means.
Thank you, Minister. I'm not a member of the Justice Committee, but I've been listening with interest to the debate this afternoon. And although going back to tradition in terms of corroboration, obviously our operational practices of the police are based around that, and we're used to seeing our police officers operating in pairs. Can the Minister give us some reassurance that if the need for corroboration is removed, that the single deployment of policemen would not be taken without the risks being fully assessed?
Cabinet Secretary. Oh, absolutely. I think first and foremost what we've got to recognise is that Lord Carloway made clear, and I think it's accepted by the Crown, that in the vast majority of cases there would be no change on the evidence that would be required, which would be preferably to have evidence from more than one source, and preferably if you can have 2 eyewitnesses, that's even better. The more the merrier. So I can give an assurance that this is not a desire to change the whole way in which the police operate, or indeed the Scottish legal system operates, but it's a matter of making sure that we go for the quality of evidence, not the quantity, and address that. Some aspects have been raised about how matters can be agreed. Equally, it would be fair to say to this chamber, I have been involved in discussions with a major Scottish financial institution at the request of one of Scotland's constabularies, but representing the views of all constabularies, because the problems that they have to have of sending 2 officers routinely down to London to pick up information that will be used in prosecutions. Christine Graham is right. We do have minutes of agreement and joint admittance of admission. Equally, there are routine matters where 2 officers required to go and pick up and speak to what is in effect a label. They don't know what's in it. They just say, I was the officer that flew south, I picked this up along with my colleague, and that before you is the item that I uplifted. That, frankly, is nonsensical. And so when folk worry about costs, let's look at that. But let's look at what other people think. I do note the statement, and I'm worried and surprised that the Tories didn't refer to it. If abolishing corroboration means that more people can be brought to trial, then that's something to be welcomed. That wasn't me, that was David McCletchie. I have to say, I'm not looking necessarily to see more people prosecuted, but I do think the right people should be prosecuted. But I do also take on board the view of Scottish Women's Aid. Our organisation's clear position is that the implications of removing the requirement for corroboration must be explored further. However, in doing that, we should not look at what will happen if that is done, but at how we can make such a move work. And I think the Tories should take that on board, by all means.
The Cabinet Secretary for taking a further intervention. Does he accept that increasing the number of accused brought to trial is a complete chimera if we do not increase the number of convictions on the basis of these persons presented for trial?
Cabinet Secretary. It's for me to increase the number of convictions. That will be for the judicial system. We have to make legislative changes that change the way the scales of justice may be balanced. But as I say, what we are looking to do is to make sure that justice is done. And that's why I would also refer to the views of Susan Gallagher, the Deputy Chief Executive of Victim Support Scotland, who said the recommendation to eliminate corroboration in Scotland is particularly welcome as long as any test applied ensures that it does actually lead to better quality of evidence. That's why I would refer the Chamber to the contribution made by Malcolm Chisholm. This is not about getting more convictions per se. I do think it is about achieving justice. If people are going free who should be convicted because they've perpetrated a heinous crime, then I think we owe it to those victims and we owe it to our broader communities to make sure that we do that. This is not simply about a system of rules of engagement between my learned friends on either side, the prosecution and the defence. It's about making sure that we deal with the requirements to address that. So it might not, by all means.
Lewis MacDonald.
I'm very grateful with the Cabinet Secretary in confirming that the objective is not more convictions, but I think accepting that the outcome will be more prosecutions. Will he accept that there are resource implications arising from that, and will he tell the Chamber how he intends to address those?
Cabinet Secretary.
patients, I think, to be fair to say, we don't necessarily accept that, and the Crown don't necessarily accept it, because it may very well be offset by the number of people who may increase their likelihood and propensity to plead guilty, because actually the evidence will be quite clear. There won't necessarily have to be the same palaver gone through. So, as I say, I think the view is that we will require to, by all means...
Christina McKelvey. Cabinet Secretary for taking an intervention and thank him for some of the reassurances he's given the Chamber this afternoon, but ask him maybe in his final comments to make some reference to the question I asked him about ensuring that the children's hearing system actually matches up with any of the changes that are proposed, especially when we're dealing with children under the age of 18.
Obviously, some of the children's hearing system will relate to civil matters where the evidence of proof is different. Clearly, those matters that are referrals follow the same circumstances elsewhere. But that's a matter that both myself and I've no doubt my colleague Aileen Campbell will deal with, and I'll be happy to come back to the member on that. On the question of resources, we don't necessarily see that there will be huge increase in resources, but what we do see as an administration is ongoing cant and hypocrisy from the Labour Party, who presided over south of the border huge cuts where we've had them slightly mitigated by the Conservative Party, as opposed to Alistair Darling's deeper and further by Thatcher. When we bring forward proposals to streamline matters, whether it's the Scottish Police Service, the Scottish Court Service, legislative changes, all we get is a palaver of matters seeking to have increased expenditure. They never come before us to tell us where they're going to make particular cuts. Equally, it has to be said that these matters will protect justice, will ensure that we protect it. But as I say, I move the motion in my name and would welcome Lord Carloway's submissions to the Chamber.
That concludes the debate on public consultation on the Carloway Report, Reform of Scots Criminal Law and Practice. We now move to decision time, and there are 3 questions to be put as a result of today's business. The first question is amendment number 4234.1 in the name of Lewis MacDonald, which seeks to amend motion number 4234 in the name of Kenny McCaskill on public consultation on the Carloway Report be agreed to. Are we all agreed? No. The Parliament is not agreed, therefore we'll move to a vote. Members should cast their votes now. The result of the vote on amendment number 4234.1 in the name of Lewis MacDonald is as follows: yes 33, no 59. There were 17 abstentions. The amendment is therefore not agreed to. The next question is amendment number 4234.2 in the name of Margaret Mitchell, which seeks to amend motion number 4234 in the name of Kenny McCaskill on public consultation on the Carloway Report be agreed to. Are we all agreed? No. The Parliament is not agreed, therefore we'll move to a vote. Members should cast their votes now. The result of the vote on amendment number 4234.2 in the name of Margaret Mitchell is as follows: yes 15, no 59. There were 35 abstentions. The amendment is therefore not agreed to. The third question is that motion number 4234 in the name of Ken McCaskill on public consultation on the Carloway Report be agreed to. Are we all agreed? No. The Parliament is not agreed, therefore we'll move to a vote. Members should cast their votes now. The result of the vote on motion number 4234 in the name of Ken McCaskill is as follows. Yes, 92, no, 0. There were 18 abstentions. The motion is therefore agreed to. That concludes decision time. We now move to members' business. Members who are leaving the chamber should do so quickly and quietly.